Be cool, be kind, be classy. The cupcakes are sweet and sexy. Have fun and enjoy the journey. Just have a good attorney. No big whoop, no biggie. She lives near New York City. Not just a YouTube show. When you know, you better grab a straw. Learn about the law. It's cool here in the shade. Sipping motions of lemonade. Cool heads will prevail. Kindness will never fail. Be classy and vastly wise. Oh, Melanie Little is going live. Oh no, where is Melanie? Follow the island's melody. Is a concert within reach. No surprise, she's at Jones Beach. She heard some music far away. Captain Jack Stack Harbor Bay. He sings and his piano plays. Not all sounds are waterways. Speaking Yiddish and Latin, it's not just for Manhattan. It's for Goethe and Machegas. Ridiculous the insanus. Oy vey, Marcus. Proceed, that's for schmucks. Be cool, be kind, be classy. My cupcakes are sweet and sassy. Not just a YouTube show. When you know. Cool heads will prevail. Kindness will never fail. Be classy and vastly wise. Melanie Little is going live.
Good afternoon. Welcome back. For those of you who are with me this morning for the Dr. Harry Turk trial, which is also happening in Norfolk Superior Court in front of a really good judge named Mark Halal. Welcome back. We have found that there is a good judge in Norfolk County, and we have found that he is currently presiding over the Harry Turk trial in the horrific killing of Harry Turk's wife at the time, Katie McLean, all the way back in May of 2020. It's finally going to trial. Kevin Reddington is the defense attorney for Dr. Harry Turk, and it is in the courtroom that Karen Reed's jury selection will be in tomorrow. So we've been watching it, and it's very interesting. What a difference a judge makes. What a difference a judge makes. Good afternoon, everyone. I was off the grid for the entire weekend. It was fantastic. It was glorious. I didn't even turn my laptop on once. And it is now out. Cat's out of the bag. I was in Las Vegas at the Dead & Company shows at the Sphere with some friends and family and somebody that you also know, Andrea Burkhart, fellow law tuber, and her husband. We had an amazing time. That's where I post my stuff, is on Instagram. So if you follow me on Instagram, you may have seen it. I also got some really good video at the Dead & Company shows of Miles Teller dancing with Andy Cohen. So that's pretty cool. It's on my Instagram story. If you're interested in that, go check it out. The link to my Instagram is below. Can't really post anything with, songs on YouTube because they strike you, but you can do that on YouTube. So that was awesome. I got to meet Andrea in person. She is amazing, even better in person than her personality is on the YouTubes. And her husband, Jeff, is also amazing. And we had a really, really, really good time. A really good time. I mean, not for a spoiler alert, but kind of a spoiler alert, because the third-party culprit decision has been logged into the computer. It is not scanned yet. As soon as I get that in my inbox, we will go over that. So I'm glowing. I had an IV. That's so funny because I had an IV in Vegas. That's the thing out there. Like, you go to these IV labs. And I had this IV for glowy skin. Yeah, I said Andy Cohen. I said it. And it was amazing. So yeah, thanks. Maybe it worked. I don't know. Not really that convinced, but who knows? Yeah. Jeff and Andrea are like couple goals. It was Andrea's birthday. So that was her birthday weekend. It was a lot of fun. And what happens in Vegas stays in Vegas, babies. So sorry, but there's that. All right, while we wait for the third-party culprit decision to come down, the first thing we're going to go over is another motion or decision that came down earlier, and in no shock or surprise, it is the ruling on whether or not Michael Easter, the FBI expert, is going to be able to come in and testify for the defense. Try not to put out any spoilers out there. We tried to keep it. Hey, Brandy, happy 44th birthday. Happy birthday. Hot off the press. This is well, not that hot because it broke during the earlier show I did on Turk. No, we don't. No, there's none of that, Blackbird. And come on, really, have some class. Don't put that in the chat, man. Did you guys already get that? Oh, that's funny. 649, docket number 649. This is the decision of Justice Kearney, the memorandum and decision of order on whether or not Michael Easter is allowed to testify at trial. My Instagram link is down in the show notes below. That's where you can always find it. Another crappy decision by Judge Kearney, and nobody, I think, at this point is shocked or surprised, but this is a bad decision. In my opinion, this is a bad decision. Also, I was just notified that this is 649. Joseph Scott Morgan apparently was just on Fox News talking about the Kearney case. Did anybody catch it live? Because I'm curious as to whether or not Joseph Scott Morgan has changed his opinion on whether or not John O'Keefe was hit by a car. Because when I had him on my show, look, I don't tell my guests what to say. I interviewed him, and this was well before, I believe, the first trial. And he did not seem to think that John O'Keefe's arm injuries were caused by a dog. And he also did not seem to think, I'd have to go back and I don't want to misquote him, but he did not seem to see a lot of issues with the evidence collection. So that was a long time ago. He may have changed his opinion since then. I don't know. But here we go. This is docket number 649, memorandum of decision and order on Commonwealth's motion in limine to exclude defense's expert Michael Easter's opinion of the investigation. If this seems a little bit blurry to you, this document, it seems a little bit blurry to me too. I just don't know if it didn't get scanned into the court system computer correctly, but maybe it's my eyes. It's quite possible it's my eyes. This is Michael Easter, the FBI expert that the defense wants to bring in to talk about how bad the investigation was, that the proper procedures were not followed. It has nothing to do with Fox News being garbage or not garbage. I just want to know what Joseph Scott Morgan's opinion was, is all. So, I mean, I don't know why that was not a open season or any sort of endorsement of Fox News. It was simply notifying you that Joseph Scott Morgan was on there. And I'm just curious about if he changed his opinion is all. Okay, here we go. And this is how she starts off her order with a quote. Interesting. Quote, defendants have the right to base their defense on the failure of police adequately to investigate ... in order to raise the issue of reasonable doubt as to the defendant's guilt in the minds of the jury. End quote, citing Commonwealth v. Finney, which was David Yanetti's case. Citing Commonwealth v. Bowden, which is the defense that the investigation was so shoddy you couldn't possibly find my client guilty, the Bowden defense. To support a so-called Bowden defense, a defendant may present evidence that certain tests were not conducted, that certain police procedures were not followed, or that certain information known to the police about another suspect was not investigated in circumstances in which it was reasonable to expect that the police should have conducted such tests, followed such procedures, or investigated such information, citing the Massachusetts General Rule of Evidence 1107. An expert may, when appropriate, be used to support a Bowden defense on matters beyond the common knowledge of the jurors. See, for example, Commonwealth v. Dyer, considering whether counsel's failure to use a forensic expert to testify about gunpowder residue and measurement of bullet trajectories deprived the defendant of a chance to assert a Bowden defense. Quote, the role of expert testimony is to assist jurors in interpreting evidence that lies outside their common experience. Commonwealth v. Shanley. Notice she's citing all Massachusetts cases in here, and there's a reason for that. Thus, the first foundational element that the proponent of expert testimony must establish is that the testimony will assist the trier of fact to understand the evidence or to determine a fact in issue. See Commonwealth v. Miranda, parens, otherwise qualified expert testimony is admissible if, in the judge's discretion, the subject of such testimony is not within the common knowledge or common experience of the trier of fact, and the testimony will assist the trier of fact in determining a fact in issue or in understanding the evidence. Citations omitted. In support of her Bowden defense, the defendant here seeks to admit expert testimony from Michael Easter, a retired agent of the FBI, to opine on law enforcement's failure to adhere to standard investigative policies and protocols in this case. More specifically, Easter's expert report indicates that he will testify that the investigation in this case was not reliable due to the quote, lack of secured crime scene, absence of a detailed crime scene log or evidence chain of custody, the failure to separate witnesses, and the premature categorization of individuals as witnesses, end quote, and potentially biased based on the failure to investigate other suspects and obtain their cell phone records. This is from Easter's report at page 15 and 16. So we're getting a little glimpse into what Easter's report said because we were not able to see it. It was sealed. The court cannot find, nor has defense counsel cited, one Massachusetts case where an expert was permitted to opine on the general competency of a police investigation. Footnote 1. They're really challenging my eyes right now. Hang on, I'll make this bigger for myself. The defendant cites Commonwealth v. Wood, where the Supreme Judicial Court noted that defense counsel, through cross-examination and the calling of its own expert, extensively challenged the adequacy of the forensic investigation conducted by the police. The court acknowledges that some forensic matters are beyond the common knowledge of jurors and therefore appropriately explained by expert testimony. That is not what the defendant is seeking to present through Easter's testimony. The lack of authority, here's what she says after that. I'm going to read the first sentence again that led to footnote 1 before I go into the next point of her reasoning. The court cannot find, nor has defense counsel cited, one Massachusetts case where an expert was permitted to opine on the general competency of a police investigation. The lack of authority suggests that during all the jury trials where the defense has been inadequate police investigation based on Bowden, expert testimony has not been needed for the jury to be able to evaluate the reliability of the Commonwealth's case and whether any failures in investigatory steps are sufficient to create a reasonable doubt of the defendant's guilt. Well, that's one way of looking at it. I would submit to you that another way to look at it is that every other judge has allowed a police procedures expert to come in and testify. And that's why there's no case law on it, because it's so obvious that it is not something that is within the reasonable purview of a reasonable juror to understand. Because based on the juror interviews that have come out, the jury doesn't even understand what reasonable doubt is. Do you really think they're going to understand what a proper police investigation is? They're just supposed to know that because what? Because they've watched entire seasons of Law and Order? I don't know. I'm confused, but I digress. Let's go back to the decision. Easter's proposed testimony concerns basic aspects of a police investigation, which are within the common knowledge of a layperson. Really? Through zealous cross-examination of police witnesses, the defendant can cast doubt on the reliability of the investigation by demonstrating how it differed from standard practices and procedures and can raise the issue of potential bias by police action or inaction, as counsel did effectively during the first trial. We're going to come back to that in a minute, but just put a pin in that. See, for example, Commonwealth v. Stedman, which stands for the proposition that Bowden defense, supported by testimony elicited from police investigator that he did not conduct criminal history check on third party, waited a week to interview him, and conducted interview for only 10 minutes. And Finney, which stands for the proposition that reports would have been admissible to show that the police were on notice of third party as a potential suspect, but that he was not investigated. Bowden, which is cited for the proposition that cross-examination was used to elicit evidence that certain scientific tests were not performed during investigation. The court finds that expert testimony is not needed for the jury to determine whether or not the investigation was compromised by any failure to follow procedures or pursue other suspects. Wow, just wow. Just wow, my head might pop off already. And we're only a couple minutes into this stream, 15 minutes in, and there could be blood everywhere. See Commonwealth v. D. Giambattista. Within the judge's discretion to preclude testimony touching on the alleged relationship between various interrogation techniques and false confessions. Commonwealth v. Tolan, not permissible for judge to preclude expert testimony on commonly understood investigation methods because such interrogation techniques can be understood by jurors without expert assistance. Well, you know what? That's a 2009 case. And the one cited before that was 2004. The defendant is undoubtedly permitted to pursue a Bowdoin defense, and the court will give the jury a Bowdoin instruction if requested. However, jurors are perfectly qualified to evaluate the adequacy of the police investigation in this case without the assistance of expert testimony as proffered by the defendant. As proffered by the defendant. Is that what I said? I'm not sure. Order for the foregoing reasons. The Commonwealth's motion in limine to exclude defense's expert Michael Easter's opinion of the investigation is allowed. XOXO. Beverly J. Canone, also known as King John Canone, Justice of the Superior Court of Massachusetts, Norfolk County, dated March 31st, 2025. That is just hot off the press today. And in my opinion, it's a bad decision. I do not think it is within the jury's common knowledge how investigations are supposed to be run. And I also do not think, let's go back to this nugget right here, where she says, through zealous cross-examination of police witnesses, the defendant can cast doubt on the reliability of the investigation by demonstrating how it differed from standard practice procedures. What if all the witnesses lie? What if that happens? What if the witnesses lie? So just in a nutshell, Michael Easter will not testify. He's not been allowed to testify on the, yes, I know that. I know it dropped the third party culprit ruling. As I said, we do not yet have a copy, but I lie because we do have a copy. We do have a copy and we're going to look at it right just now. So thank you, Suzanne, for being the first one out with it. But really, what if the police investigators lie? Apparently they don't know how to do an investigation. They certainly don't know how to do one in the snow. And so in my opinion, I do not think that this is within the common knowledge of a jury, how a police investigation is supposed to be done, how it's supposed to be done in the snow, how the crime scene is supposed to be secured, because through cross-examination, they might say, we don't know. We've never had to do an investigation in the snow before. We don't know. It doesn't really snow too much here in Massachusetts. Oh, we don't know that it's important to secure a crime scene because, we don't know. Yeah, Todd McGee would be great, but apparently they're not allowing any sort of expert witness to testify with regard to police procedures because the judge thinks everyone has watched Law and Order every season and perhaps every other CSI television show out there, and they should understand and know how an investigation is supposed to be done, and that cross-examination should be able to, root all that stuff out. And that's how they should be able to do it without expert testimony. I strongly disagree with this decision. I think that this is the bias on the part of the judge is showing, in my opinion. And I think they absolutely 100% need an expert in police procedure to point out all the ways that this should have been done, that the witnesses should have been separated, that the witness statements should have been recorded, that the crime scene should have been secured, that there should have been logs of evidence, that there should have been a log of every person who came onto the lawn of 34 Fairview. And so I strongly disagree with this decision. Can they make a motion to reconsider it? Yeah. Jury selection starts tomorrow. So there's that. They can make a motion to reconsider. Bad decision. It's junk. It's junk. Let's go to third-party culprit decision that just dropped. No spoilers, please. I can't believe I still have to say that, but I do, because people like to be the first to, bring the news. And I can't blame you for wanting to share the news, but there are a lot of people in this chat who are not on Twitter, and so they didn't see it. Thank you, Suzanne, for getting out first with this. This is docket number 652. Docket number 652. Second. Settle in, folks. Get a drink. Get your popcorn. We're going to be here a while. We have stuff to still go over from next week. From last week. And, that surprise hearing and other things. This is docket number 652. Docket number 652. Breaking. Memorandum of decision and order on Commonwealth's motion in limine to preclude the defendant from raising a third-party culprit defense. This is a cold read for me. Haven't seen it. First time out. First time, long time. And I'm going to get my red pen ready. Thank you. Thank you for reminding me. And also, it's only 4 pages. It's only 4 pages. Unlike the motion to dismiss, which was something like 26 pages. This is the memorandum of decision and order on Commonwealth's motion in limine to preclude the defendant from raising a third-party culprit defense. The Commonwealth has moved to preclude the defendant from raising a third-party culprit defense. The defendant has alleged 3 potential third-party culprits: Brian Albert, Brian Higgins, and Colin Albert. For the reasons that follow, the Commonwealth's motion is allowed in part and denied in part. And I seem to remember, you can correct me, Chad, if I'm wrong, but I think that was the decision before the first persecution of Karen Reed, is that it was denied in part and allowed in part. Let's see if it differs. I don't know if I have the old order in somewhere in my computer. I might. But let's read on. The opportunity to present third-party culprit evidence is guaranteed by the Due Process Clause of the 14th Amendment because it is rooted in the right of criminal defendants to a meaningful opportunity to present a complete defense. Okay. First of all, I don't like this phrase, the opportunity to present a third party. She's not getting an opportunity. She has the right to do so. It's a right, not an opportunity. Don't make it seem like it's a privilege, Your Honor. But again, at least try and hide your bias a little bit. See Commonwealth v. Scott, quoting Crane v. Kentucky. Quote, a defendant may introduce evidence that tends to show that another person committed the crime or had the motive, intent, and opportunity to commit it. However, defendant's latitude to introduce such evidence is not boundless. Quote, the defendant's ability to mount a third-party culprit defense is not without limits. So we're in the outer limits at this point. Evidence that a third party committed the crimes charged against the defendant or had the motive, intent, and opportunity to commit the crimes is admissible, provided that it has substantial probative value and will not tend to prejudice or confuse the jury. Commonwealth v. Watkins, quote, proffered evidence must have a rational tendency to prove the issue the defense raises, and the evidence cannot be too remote or speculative. Colin Albert, or Colin Albert, depending on who's pronouncing his name. As to Colin Albert, the defendant's proffer contains no additional evidence than that presented at the first trial, and it is insufficient to support a preliminary finding that Colin Albert had the motive, intent, and opportunity to commit the crime. Before my head pops off, let me just continue reading because this may resolve itself in the next paragraph. The evidence of opportunity is wholly inadequate. There is no evidence that Colin Albert was at 34 Fairview when the defendant and Mr. O'Keefe arrived at the home. I'm sorry, what? There's no evidence? No, there's conflicting evidence. There's conflicting evidence. Just because every one of Colin Albert's relatives say that he left that house at 12:10 doesn't make it true, Your Honor. It doesn't make it true. See Commonwealth v. Fitzpatrick. Third-party culprit evidence is properly excluded where there was no evidence third party had means or opportunity to commit crime and evidence of motive was speculative and too remote. Here's what she says. Wait, hold on. Evidence at the first trial was that Colin Albert had already been picked up by the time O'Keefe and the defendant arrived at 34 Fairview. I call bullshit. I call bullshit. This is a question of fact for a jury. This is a question of fact for a jury to decide. This is not an uncontested fact that should be put in your court order as truth of the matter asserted. Okay. It's up to the jury to decide that, Your Honor, not you. Colin Albert didn't remember anything about anything except for he left at 12:10. There's conflicting evidence about who he passed in the foyer. Aunt Coco and Uncle Bri. There's conflicting evidence of who picked him up. There's conflicting evidence of Allie McCabe's Life 360 data. There's going to be a witness who's going to come in and testify that Colin Albert called her at 12:33 a.m. asking for a ride. This is insane. And if you didn't think that this court, this entire Norfolk County District Attorney's Office is in place to solely protect the Alberts and the McCabes, then I don't know what to tell you, because this should prove it to you just about now. As to motive, the defendant contends that Colin Albert had been in a feud with John O'Keefe in the weeks and months leading up to O'Keefe's death, and that Colin Albert had thrown beer cans on O'Keefe's lawn and swore at him. There was, however, no evidence substantiating these claims at the first trial. I don't give a shit. This is a new trial, right? It's a new trial. Isn't this? Didn't she say about 100 times that this is a new trial? Isn't this a new trial? Aren't they entitled to call new witnesses and other witnesses who may establish that? And perhaps, maybe, I don't know, they've got a geofence expert who's going to put Colin Albert in the house after 12:10 a.m. I don't know if that's true, but one of the expert witnesses that's going to testify on behalf, or wait, was that Easter, who is the geofence expert? I think it's a different expert. Refresh my recollection, chat. We'll see. Moving on. As to motive, yes, motive. Okay, beer cans. There was no, but note one. To the extent that at the upcoming trial, the defendant would offer hearsay testimony to support the claim that Colin Albert had a feud with O'Keefe, to be admissible, such evidence must otherwise be relevant, not tend to prejudice or confuse the jury, and there must be other substantial connecting links to the crime. See Commonwealth v. Rice, 2004. The proposed evidence does not provide a substantial connecting link between Colin Albert and O'Keefe's death. As to motive, let's just say the Commonwealth doesn't have to show motive. Neither should the defense. Sometimes drunk people fight. Sometimes people who like to fight just like to fight. Sometimes when they're drunk, they could jump into a fight that they had nothing to do with. Don't you think that's for the jury to decide, though, if we really want to get at the truth? Or are we just here to protect Colin Albert, who's now a grown man, or an adult anyway? He's over 18. I think he was under 18 at the time. Wow. Even if there was evidence of some ill will between O'Keefe and Colin Albert, motive alone is not enough to demonstrate third-party culpability. Commonwealth v. Martinez, 2021. See Commonwealth v. Buckman, 2011. Fact of tensions between the neighbor and victim was not indicative of the neighbor's motive to kill, and the defendant offered and produced no evidence suggesting that the neighbor had any opportunity to kill beyond that possessed by any neighbor. Well, I mean, Judge Kearney has just told you that Colin Albert was not in the house, just like Michael Morrissey told the worldwide audience and the entire jury pool of Norfolk County in August of 2023 through his hostage video that may or may not have been suggested by Colin Albert's mother, Julie, that Colin Albert was not in the house. That was in August of 2023. And that is used in law school classes right now to teach law students what a district attorney should not do. Moreover, the theory that Colin Albert is the third-party culprit because he had scraped knuckles at some point after O'Keefe's death had been seen in a video drunkenly taunting others with no connection to O'Keefe, and apparently was not named in police reports is speculative at best. Right. Right. And that's why the Duckin jury should decide. That's why the jury should decide. Because there's just a few too many coincidences in this case, Your Honor. I need to read that again for effect, because if you know a lot about this case, this whole entire paragraph might shock the bejesus out of you. Shouldn't those things that she just set forth here, that he had scraped knuckles at some point after O'Keefe's death, had been seen in a video drunkenly taunting others, pull up, biatch, bang, bang, to like another town's hockey team over girls? And if he's 17 years old, because they're calling him like a toddler, practically, the friends and fam, why is he drunkenly doing anything at 17 years old? Why is he drunkenly taunting anyone? He's 17. Why are all of these parents and family members condoning their 17, 16, 15-year-olds getting drunk and sliding down driveways in the ice because, got to protect the beer that's in the other hand. So, the knuckles went down on the driveway. He remembered nothing except for exactly how he scraped his knuckles. Exactly. He left that house at 12:10. And that he went up 3 flights of stairs when he got home to kiss mommy and daddy goodnight at a time when we know, I think, or we've learned, that it is questionable whether or not Chris Albert was even home at that time. Isn't that exactly, and the fact that he was not named in any police reports, speculative at best? No, I would submit to you that is exactly why all that evidence should come in, so that the jury can decide why everyone is lying. Why everyone is lying. Why nobody mentioned him as being in the house at any point that night. Because remember, they rattled off a whole bunch of other people that were in the house that night that weren't around by the time John and Karen got there. They were named. Colin Albert never was. Ask yourself why. The jury should be able to ask themselves why. Then she quotes Acevedo. Third-party culprit theory that victim was shot by unnamed rival drug dealer was based on rank speculation and properly excluded. Commonwealth v. Andrade. Evidence that rival gang members lived near shooting and were involved in feud with victims not sufficient to support third-party culprit defense, where there was no evidence that they had been nearby at time of shooting, and theory was speculative at best. Allowing such feeble third-party culprit evidence poses a risk of unfair prejudice to the Commonwealth and would only serve to confuse the jury. Did she really just put that in her order? Unfair Commonwealth? I'm sorry. I can't even think straight. I'm blinded by the insanity of this decision. Sorry. Hold on. Let me try and get it together. Feeble, first of all, is a word that Hank Brennan used at least 17 times during his argument of this. So it's so cute that now we're going to quote Hank Brennan, and which is apparently quoting the Silva Santiago case. And then it poses a risk of unfair prejudice to the Commonwealth. Well, I thought we were here to try and get a fair trial for Karen Read. Isn't that what we're supposed to be doing in the interest of justice? Is that what we're supposed to be doing? Are we looking for a fair trial for Karen Read, or is it all about unfair prejudice to the Commonwealth? We don't want to get at the truth. We just want the conviction. We want to pin it on the girl. We're this deep into it. We got to keep it going. It's insane. Accordingly, evidence that Colin Albert is the third-party culprit is excluded from the trial. Wow. Wow. Wait a minute. You mean even after Julie Albert may have suggested to Michael Morrissey to make that hostage video, clearing her son Nobody ever knew he was there. Nobody even interviewed him until something like 18 months after January 20th, 2022. But hey, can't bring it up now. No, Colin Albert is allowed. Wow. I mean, if you had any doubt about who's being protected here, boop, there it is. There it is. I rarely get speechless, but I'm going to try and keep it clean. Brian Albert and Brian Higgins. As to Brian Albert and Brian Higgins, the defendant's proffer is barely sufficient, and the history of the first trial casts doubt on the seriousness of the claim. Wow. Let's just put it all out there. Tell us how you really feel, Judge. Well, I don't know. I mean, I don't know. I kind of feel like this would be a good basis for a motion to accuse because her bias is so obvious right now. I thought this was a new trial. Why are you basing your decision on everything that happened at the first trial? There's a whole new list of witnesses. I don't know. It's just my opinion. However, to protect the defendant's right to a fair trial, now we're going to be concerned about it, but we really got to protect Colin. But in order to now protect the defendant's right to a fair trial, and in recognition of the fact that the defendant has no burden to prove anything under our law. Wow, thank you so much. That's so generous of you to put that in your order. The defendant has no burden to prove anything under our law. The court will take the same incremental approach as it did the first trial. Defense counsel are ordered not to mention potential third-party culprits in opening statements, but counsel will be allowed to develop the evidence at trial if possible, and counsel may seek an appropriate instruction if warranted after the evidence is concluded. Oh, thank you so much for your grace and your generosity and your stating publicly that you'd like to give the defendant a fair trial, even though she's not allowed to mention anything about Colin Albert, because protect Colin Albert. Is that a hashtag yet? Hashtag protect Colin Albert. Footnote 2. The court notes that the defendant at the first trial, under an identical order, did not seek an instruction on third-party culprits. Oh, well, yeah, just got to put that dig in there too, don't you? Though the court may ultimately exclude the proposed third-party culprit evidence. Oh, so she's reserving her right to say, no, at trial, I may not let you even talk about it at all, or counsel may abandon the theory. That does not mean that the defendant cannot offer the evidence to show the inadequacy in the police investigation, provided the proper foundation has been established. Yes, except for the order that you dropped right before this one is precluding their expert on police procedure and investigation. So you did that right before you dropped this. So yeah, they're supposed to do that without an expert. But oh, thank you so much, Judge, for your generosity. It is hereby ordered that the defendant is precluded from raising a third-party culprit defense alleging Colin Albert is culpable for John O'Keefe's death. The Commonwealth's motion is allowed as to Colin Albert. The defendant is not prohibited from raising a third-party culprit defense as to Brian Albert and Brian Higgins at this time. Counsel cannot mention potential third-party culprits in opening statements, but will be given the opportunity to develop the theory through relevant, competent evidence at trial, which, in my opinion, she's going to exclude all of it because she reserved her right to exclude it in the paragraph ahead of this one. The Commonwealth's motion is denied as to Brian Albert and Brian Higgins. XOXO. Justice Kim Jong-Kanone, Justice of this Norfolk Superior Court in the state of Massachusetts, dated March 31st, 2025, which is, I believe, today. Because, yeah, tomorrow's April Fool's Day, and that is the fitting day to start picking the jury on this shenanigan of a mishigas, upside down, inside out, Narnia of a courtroom. We are so far back into that wardrobe that we are through the door, and we are, wow, way, way far into it. Or maybe instead of, putting little stickers that say, Colin did it on the bottom of little rubber ducks, it should say, protect Colin. Misha says, I pray the jurors will have sense. Listen, we all pray. We pray. Lord, hear our prayer. Lord, hear our prayer. However, based on the interviews of some of the jurors from the first trial, they didn't even understand reasonable doubt. So my faith in the jury system It was restored during the Brian Camp case. I have to say that. He was acquitted. We saw Penny McGee acquitted on a bench trial by Judge Kearney, which was shocking in and of itself based on the way she seems to be swinging over here. But the jury is not going to get to hear expert witness testimony about how investigations are supposed to go. They're just supposed to, cross-examine these witnesses about their piss poor investigation and hope they tell the truth about how it's supposed to be done. How in what world would they testify about how it's supposed to be done when they didn't do it the right way? Do you really think they're going to come in and say, yeah, completely, all these missteps, yeah, threw John O'Keefe's clothing in the backseat of my car, was never supposed to do that. It's a tale of two cities, yeah. But chain of custody logs, yeah, we don't have them, but now we're creating them. And, we don't have any metadata. Somebody explain this to me because my head is going to pop off. Oh, let's go to the chat because you guys have a lot of questions, comments, concerns, and rightfully so. So if you're just tuning in, welcome. Happy Monday, everyone. Welcome to the eve of trial where Justice Kearney has just decided to protect Colin Albert fully 100%, full stop. No backsies, do not pass go, do not collect 200. Colin Albert is not allowed to be implicated in any way, shape, or form by any testimony that may indicate that he may have had some part in causing the death of Officer John O'Keefe. However, Brian Albert and Brian Higgins remains to be determined. Maybe you can submit some evidence and I'll decide later whether or not I'm going to let you. I'm going to let it in. Because, Commonwealth is entitled to a fair trial. And I need to digest this for a second because this was a cold read. So let's see what you guys have to say about it. Thanks, Rebecca, for becoming a new member. Welcome. Louis Alberts in Scissors is here, bringing the Canton chaos. Laura says, I like the way Judge Halal, that's the judge in the Turk case, explains his rulings much better than Judge Because I Said So Kearney. There's a lot of bias and speculation. Yeah. Thanks on top. Be a super sticker. Be made defense should call Rafferty to discuss since Easter is denied. She should be called anyway since she gave the thumb drive to Proctor with the note. Yeah, she should be. But again, calling a witness in your case in chief, if you're the defense, is you can't cross-examine them. You have to direct examine them. So I disagree with this ruling very, very, very strongly. And I don't know that would, I think it's a great, it's a great idea. Would it rectify this Michigas of a ruling? I don't really think so because I don't really think that she's going to be 100% truthful. And not to mention, Canton PD was conflicted off this case. But, because we're just supposed to sit back and take it. Ashley says the investigators in this case aren't aware, never mind the jury. Right? Exactly, Ashley. Can exclusion of witnesses be appealed pre-trial? This is evidentiary. I don't know if it's an interlocutory appeal issue. I don't know if there's very, very narrow, slim grounds for an interlocutory appeal. And because it's evidentiary, the answer is maybe. I don't think they're going to spend time on it. They can ask her to reconsider. There's other avenues here. Lori Joyce cast doubt as if the jurors would believe the defense, as Ronnie called that, distractors. And I haven't had a chance to digest it, so let me think about that. Sarah Berger, can they add to the questions of the other witnesses that dig out the same information? I'm not sure if I'm behind. Are you talking about third-party culprit? I'm not quite sure what you're asking. Or are you talking about the Michael Easter testimony? How far behind am I? Well, that was from 320. The answer is I don't know if they can do an interlocutory appeal. Stina, so does the defense go through their operating policy procedures and manuals one by one with each cop? I don't know that they have one. I don't know that it's ever been requested to be turned over. I don't know if it would be admissible to go through their operating manual, and I don't know that that's ever been requested by the defense. But that's a great question. Thank you for your 5. Riley, did my forensics ed in Florida and we learned snow info. Okay, great. Thanks, Riley. JB, Like the YSL case, can the defense raise an issue with the judge, or is it after trial issue? She's so corrupt. They made, before the first trial, they made a motion to recuse, and they had a lot of evidence that gave her every opportunity to recuse herself. She decided not to, and not having followed the YSL case like at all, I can't compare and contrast. But thank you for your super chat. Fire and Acid. We watched a trial last week. Defense hired FBI expert about investigation, and she was not guilty. What trial was that? Fire and Acid. Thanks. Thanks for your super chat. IQ. I'm so stressed out to watch this trial again. So obvious Bev is going to make it so difficult for the defense. Poor Karen. I agree. Thanks for tuning in from Canada, Cat Q. Seems Bev doesn't want unbiased cops as witnesses. Right. Thanks for pointing that out. Nothing to see here. And for your super chat. And isn't this for the finders of fact? Yes, Ange. The finders of fact are the jury in this case. It's not a bench trial. And so her proclaiming that stuff as being actual evidence when really there are some questions of fact there is mind numbing to me. But nothing surprises me. Every day, every ruling, I guess I should just learn to not be surprised, because surprise, we're still here and this prosecution or persecution is still happening. Bev is the judge and jury. I never doubted she was biased. Thanks, nothing to see here. Appreciate you. Double M99. Can the defense FOIA the MSP standard operating policies and procedures? I'm sure it's probably available online. I don't know that you would even need a FOIA request for that, but I don't know the answer to whether or not it's available through FOIA, or if it's just posted online, or if it's more easily, it may even be more easily accessible than that. I would assume they are public record, then query the investigating officers on cross or direct if those policies were adhered to, and if not, why. I mean, that's a great avenue. But again, in my opinion, it's much more effective to have an expert witness testify to this, right? I think it would be much more effective in front of a jury. And if I get one more spam call from a 315 area code wanting to give me some sort of loan, literally 10 a day. Does anybody know if the do not call list is a thing anymore? Does it exist? So the answer is yes, they could probably do that. But the answer is, why should they have to, right? How about each one of them testifies about all the crappy stuff that they did and how piss poor the investigation was, and then have an expert come in and say why that's not how it's done. Mind blown. Thank you, Double M9 for your 20. Katie says, Bev clearing Colin Albert in her order is wild. Yes, yes. And Michael Morrissey himself, the big head mofo in charge, tried to do that with his August of 2023 video hostage statement that he taped in his office and sent out to the media, because we saw David Traub's emails back to what Betterow has pointed out as probably Julie Albert and Chris Albert, who was a town selectman at the time. He's blasted that statement out to Nightline, Dateline, all the usual suspects, Gretchen Voss, everyone. It was not a press conference. There were no questions. It was just a taped hostage video with someone off camera, in my opinion, holding a gun at his head, and he was reading a prepared statement. Because I bet you they don't have a teleprompter in the DA's office, but maybe they need one. Thank you, Katie, for your super chat. Can the defense show Morrissey's hostage video? I don't know. They have him on the witness list, and she's not decided whether or not she's going to let him testify, or maybe she decided that they're going to have to do a proffer if they want him to testify, but he is allowed to be in the courtroom. I think he is not subject to the sequestration order, Michael Morrissey, and the victim witness advocate, I think, also is not subject to the sequestration order. You can correct me in the chat if I'm wrong, because these rulings keep coming out day after day after day. And they're kind of hard to not conflate and keep straight. Double trouble. Can't this be revisited if the other witnesses testify he called her at 12:33 to pick him up from 34 Fairview? Doesn't sound that way. It doesn't sound that way from her order. And so she may not even let anybody open the door on that. Double trouble 247. So thank you for your super chat. That's what I'm thinking. No, I already ruled pre-trial that you're not allowed to bring Colin Albert into this because of what I said in my order. And therefore, you can't question anybody about who he called at 12:33 to ask for a ride from 34 Fairview. It's my prediction. I could be wrong, but I'm usually right. The magic 8 ball and I. Because really, that's what you really just need to do. Whenever would the judge do this? Would the judge do that? What will happen? Just shake the magic 8 ball, because really, this is probably more accurate than trying to predict what this judge is going to ever rule on anything. You're better off walking into a casino, dropping 10 grand on black or red and spinning the roulette wheel, because you never know. And says they talk about the Commonwealth like they're the defendant because that's what this is really about, defending the Alberts. Yeah. Well, I mean, if it wasn't clear to you until before today, it should be now. Nothing to see here. I'm so disgusted. This is why it's scary for Karen. Thank you. Shame on you, Beverly Canoni, says Helena Frost. Bias Bev. For protecting colon, this tells me one thing. Thank you on top. Thanks for Rebecca for becoming a member. Annie Bev's Kangaroo Court and Three Ring Circus. Thanks for the 10. Can they use the Dighton officer to discuss what a standard procedure would be to get that in, since they can't get Easter in? I don't think so. I don't think so. Because again, he's not an expert. So I don't understand that ruling, because to me, it is not in the common purview of a layperson how police investigations are supposed to be done. Right? Because what they do in Dighton may be different than what they do in Canton. Like this guy, this is an FBI trained expert who trains officers on how to conduct investigations. Like a Dighton officer wouldn't be an expert in that. The whole thing makes no sense to me, and it's in my brain right now, and it's so tangled that I just can't even. They were both a cold read for me, so I have to digest this a little bit more. Thank you, Andy Bev's Kangaroo Court. The Mimi Sue, I'm so godsmacked denying Bowden and she's not denying the Bowden defense. They are allowed to talk about how crappy the investigation was. They just can't have an expert testify about how crappy the investigation was. But they're allowed to cross-examine the witnesses. But third party only denying Colin Albert. Maybe Brian Albert and Brian Higgins, if she feels like it later on. Thank you for your 5. Hates me. The defense can't put on any case with these 2 rulings. Thank you, Hates me, for your 20. We don't want to prejudice the Commonwealth, though, do we? I mean, really, isn't it about a fair trial for the Commonwealth? Oh, thank you, Nicola. Says, I'm so happy you had a break from this crap with the $2 or the 2 and 222. Super chat. I appreciate you. Those are angel numbers for those of you who don't know. Thank you. Yeah, it was good to get a full weekend off and not have to think about this at all, because this is like it's exhausting. Cat artist, Beverly Canoni, wouldn't you like to retire? No, thanks for being with me for 8 months, cat artist. Love you. Flemic Celeste says, I want to hear what the defense bar of Massachusetts has to say about Easter. Can they pull trials where it was allowed from the get? Apparently, there's no Massachusetts case law on this type of expert ever being allowed in Massachusetts, because according to the judge, one has never been allowed in. Isn't that what her ruling said? I'd have to go back to it, but they could. And I think that I'm sure the Bob Alessi's head has popped off already today. That's the second that ruling came out. And I'm sure he's furiously writing right now to reconsider. And perhaps that's what he'll do. Abacus Flinch, this is feeling more and more like the Commonwealth and McAlberts are hanging Higgins out to dry to protect Colin. Higgins and Proctor, are they going to be the 2 fall guys? Maybe. Thanks for your 10. Karina, time to ask her to recuse herself again, please. Is it too late? Is the motion deadline over? I think so. Jury selection is tomorrow. Remember, was it intentional that these rulings are just magically appear on the eve of trial? You decide. Nina, it feels like Judge Canoni feels threatened by the expertise of Karen's lawyers. She just keeps trying to tie their hands. Yeah. Yeah. The Commonwealth, if the Commonwealth really wanted a fair trial, they would just let everything in and they wouldn't fight all of these experts, because they would want the truth to come out, but they don't want that. They want the conviction. Casey, I'm a Massachusetts resident. This case has made me cry and yell from frustration and anger. I've completely lost all hope in our system in Massachusetts. Free Karen Reed. You're not alone, Casey. You're not alone. Kat, maybe Judge Canoni is Colin's godmother. They all seem related in this case. Lou, the light most favorable. Why else the bias? Agreed. Zach, can the defense still impeach Colin about not being in the house, not being in fights, and about his knuckles around the time of John O'Keefe's death? Seems to me. Let me go back to the ruling and just read it a little more closely. Accordingly, evidence that Colin Albert is a third-party culprit is excluded from trial. So all of that stuff about the condition of his knuckles, not being in fights, not being in the house, I guess none of that would be relevant evidence according to this judge. She's not going to allow any evidence that he was a potential third-party culprit, right? Welcome. Welcome to the courtroom of Kim Jong-Kanone. I'm just... Karen Reed is so fucking innocent. This is outrageous, and I'm outraged. We are all outraged. We are collectively outraged. Thank you, Anna, for your super sticker. Lady Zelda is here. She reads tarot cards. She has a channel. She has a lot of interesting tarot card reads. And I don't know what that's called, Lady Zelda, when you do that thing, when you're like talking to the spirit of John O'Keefe and you have the words come up on your computer, but it's really cool. Now we know guilt by omission. Thank you, Lady Zelda. Lisa Liu, could defense question these cops on certain procedures they did follow correctly in other cases such as Walsh? Well, I would say it opens the door. If she's not going to allow an expert to testify on that, that may open the door to such things as you're suggesting. Originally, I didn't think she would allow that stuff in, but I think there's a good argument to be made there, Lisa Liu. So thank you for bringing that up, because again, I could shake the 8 ball, or I could say, yeah, maybe she'll let it in, or just maybe she'll shut the whole thing down. Or, you know, we talked about this also after the first trial and the pretrial leading up to this one, before we had any notice of who the 12 experts were going to be on behalf of the defense. And people were asking a lot, you know, can there be a police procedures expert? And my opinion had always been probably not. She probably wouldn't allow it. But then when I saw this motion, I thought it was fantastic. And this is what Alessi does. And he knows what he's talking about. But again, no, not according to this judge. Lori thought maybe Bev denied expert Easter because he was FBI. We know how much Bev and Hank hate the feds. I don't know. I don't think it would have been, I think the decision would have been the same no matter where he was from, if he was from MSP or if he was from FBI, because that was not like part of the reasoning for her ruling, but I could see how you might think that. Thank you, Shannon Merlino, for your super sticker. Kevy Kev, thank you for everything you do. Thank you for Karen and John O'Keefe. The feds are watching. Chat, it's not over yet. Thank you, Kevy Kev, for being seeing the silver lining in all of this. Nobody really knows, right? Double Travel, check out Turtle Boy's reporting about Hank representing a dealer and getting paid in cash. When I have a spare minute to do some homework, I absolutely will. Unless you're talking to the rest of the chat and pointing it out. Haven't seen it. Been off the grid all weekend and really enjoyed it quite a bit, I have to say. Lucci. It's going to be difficult to get a jury that isn't well informed on this case. The world is talking about it. Colin's name is out there. She can give all the orders she likes. It won't help them. Right. But the thing is, they can't talk about it during the trial or bring up any evidence about it. So are they going to have to now focus their efforts on Brian Higgins and Brian Albert and hope that perhaps somebody out there, some random citizen who knows something, is actually going to contact the defense team and say, hey, guess what? I know what happened. I was there. Maybe Steve Scanlon will have a change of heart and come in and talk about what he knew and how he knew it. Thank you. I appreciate the optimism, but I don't know. Thank you so much. Katie, didn't the jurors say it would have been helpful to have an expert on the police procedures and such? One of them might have said that, Katie. I don't remember, but I'll trust you on that. Trisha became a member. Welcome. Amara, if she ordered, they can't include Colin Albert as a third party. What happens if the Commonwealth brings it up? If they open the door? Well, I'm pretty sure they're not going to open the door and they're going to leave that door slammed shut. But again, if the door is opened, sometimes that can be a good argument to let stuff in. Wow, just wow. Well, Here's what we can do next, because, we're here for all of it. All of it. Let's look at the combined witness list. The combined witness list also came out today because the judge wanted a combined witness list for both sides, which is docket number 647. Docket number 647. Let's take a look. Another cold read for me. Haven't seen this yet. So if you have, and you can point out some things that I might miss being a cold read and all, please let me. This is 6 pages long. This is docket number 647. Yeah, Swiss Miss, I'm exhausted too. This is exhausting. It's exhausting. Imagine being Karen Reed and her family having to deal with this every single day. 1 step forward, 10 steps back. 1 step forward, 10 steps back. John O'Keefe was not hit by a car, and a car did not hit John O'Keefe. And that's the be all and end all of it all. That's how simple this case really is. The injuries to John O'Keefe's body do not line up with the pedestrian versus motor vehicle car accident. They just don't. They just don't. And the fact that she's going to let this Dr. Isaac Wolf come in and testify about the hardness of the ground causing these injuries is mind-numbing. Chasing dreams, we can always hope. Says, hoping Mr. O'Keefe and Aaron step up and do what's right. If they know anything. I don't know that they know anything, but I mean, that's great. Thoughts on if Steve Scanlon was the tall guy with the dark hair? Trooper Paul's pirouette. I never even crossed my mind. But yeah, who's this tall guy with the dark hair that Higgins says he saw come into the house? He's already testified to that, so he's going to have to be hammered about it this time. Wow. Huh. Right. If you can't win fairly, change the rules, says Ange. Yeah. Yep. All right. Let's take a look at the combined witness list. See what all of you eagle-eyed eye spies can spot here. Docket number 647. Docket number 647. This was just filed this afternoon. Number 1 on the witness list is Aidan Kearney. Wow. Oh, I guess it's alphabetical. Okay. All right. It's alphabetical. It's alphabetical. I was like, really? He's number 1 on the call sheet? If you know, you know. Number 1 on the call sheet. When you're an actor, it's always the most important character in the script, in the show, in the movie. It's number 1 on the call sheet is the top dog. But Aidan Kearney has made number 1 on the call sheet, everyone. To Isaac Wolf, that is the brain surgeon that's going to come in and testify as a witness for the Commonwealth, talking about how hard the ground was and causing the brain injuries to John O'Keefe. Alfredo Lopalato, he's one of the brothers that Michael Lank wrongfully persecuted. Town of Canton was sued all the way back, whatever year that was, refresh my recollection, 2007, because Michael Lang has been inserting himself into Albert family business for decades. They sued the town of Canton. They got paid something like $300,000 in a settlement against Lank and the Canton PD. And let's hope they do come in and testify this time. Allie McCabe is on the list. Andre Porto, he was the Massachusetts State Police Crime Lab, one of those guys. Andrew Klain, not ringing a bell right exactly this second. I think he might, was he an ARCA witness as well? No, this guy's from Bridgewater. Dr. Rentschler, Angela Malvone, Annie Chung, Anthony Flamati, Ashley Bell. A lot of these we went over because Aidan Kearney has done reporting on a lot of these people before the first trial. There are some prior victims of Chloe who were bit by Chloe, at least one. I think there's a person who was bit by Chloe after January of 2022. Ashley Vallier, she's the MSP Crime Lab. Brian Albert Jr., Brian Higgins, Brian Lachlan, Brian Wanless. Okay, there's 1, 2, 3, 4, 5. 5 Brians on the list. Brian Wanless. They didn't call him at the first trial, but is he the one who removed the taillight and that's when it fractured or exploded or shattered in the Sally port. Yeah, alphabetical by first name. I have no idea why. Why do they do anything the way they do it in Massachusetts? Lightning Leaf? I don't know. I don't know. Hang on. Bridget Meehan, I believe that she is the I don't think she's the keeper of record of Canton. I think she's the owner of the Waterfall Bar, right? Caitlin Albert, Lieutenant Charles Ray, Canton PD, Chief of Police Helena Rafferty. That is going to be a fantastic cross-examination if the Commonwealth calls her on their case in chief. Chris Von E, he's an expert. Christina Hanley, Chris Albert, Christopher Curran, Colleen Crawford. That's going to be a fantastic cross-examination too. Colin Albert. Well, I wonder now. I wonder if now that Colin Albert's out as a third-party culprit, if the Commonwealth will even call him at all. I bet they won't, because what does he have to add? Nothing. The only reason he was called last trial is to get out ahead of the Colin Albert being a third-party culprit. They probably won't even call him. Why would they? He's got nothing to offer. According to them, he wasn't in the house when John O'Keefe was there, right? They won't call him. Agreed. I agree. It's going to be a different trial. Thank you. Andrew Klein is a forensic expert accident reconstructionist. Is he for the Commonwealth? Good Norfolk County citizen? Or is he part of the ARCA team, or is he for the defense? I don't recall right now. Aperture. He's on the defense list. He's on Aperture. He's on. So that's the Commonwealth list, right? They have all the. Klein is a retired MSP of 29 years. Okay, that's refreshing my recollection. Recollection is refreshed, and I believe it is a Commonwealth witness. Yes, thank you, Kim. Oh boy, it's exhausting already. Courtney Proctor, Kurt Roberts, husband of Carrie Roberts. She's a talker. Daniel Whitley, Daniel Wolf, Crash Daddy. Derek Ellington of Wake Forest, North Carolina. I wonder if he's one of the guys on Chippy's text messages. I don't remember. Yep, alphabetical by first name. I know. I don't know why either. I don't know who typed it. We know Hank's paralegal hates him, so maybe she typed it. I don't know. And then they put Dr. Marie Russell in the D's, because D for doctor, D for doctor, not M for Marie, D for doctor. But what's funny is none of the other doctors are in the D section, like Elizabeth LaPosada, which, by the way, was just pointed out to me that Dr. LaPosada is also going to testify, I believe, in the Turk trial, right? Refresh my recollection, chat watchers that are watching the Turk trial with me. Why is Dr. Marie Russell in the D's instead of in the M's? And why are none of the other doctors in the D's? Just another day. Just another day. Every day is a new day here. They didn't want the Alberts at the top. Oh, that's a great point, Carrie. I didn't think of that. Great. Huh. Anne says, I just want to see the defense make a chart of all the coincidences in this case for their closing. I love demonstrative exhibits. I think the jury needs them. I think that some people are visual learners, and to see charts in closing and PowerPoint slides can be very effective. We watched it in another trial, and I found it to be very, very effective. And I forget which one, but it was during closings. More visuals. It's alphabetical, but it's by first name. Elizabeth Proctor, who's the wife of Michael Proctor. Why are they going to? Oh, maybe she's on the defense's list. Remember, this is a combined witness list. Eric Hanlon. I believe Eric Hanlon's a real estate agent. Erin Beatty. That is the girl that allegedly Colin Albert called at 12:33 to come pick him up at 34 Fairview. Erin O'Keefe now lives in West Bridgewater, Massachusetts. Well, Oh, another reason perhaps they did this by first name is they didn't want all the O'Keefes listed together so that we could see that they all live in different places now, maybe. Haven't seen the ruling on ARCA yet. I haven't seen it yet. But if it drops while we're here, we'll do it because we're here. We're here for the long haul today. Today's the eve of trial. Third-party culprit dropped while we were sitting here, and we've already done it. So if you haven't seen it, you might want to rewind because it might blow your head off. Or at least pop your head off. Let me just go back to the docket for a second. So Aaron O'Keefe is now living in West Bridgewater. Francis Walsh, Canton Fire Department. Garrett Wing is on the list. We don't have a ruling on him yet, but Garrett Wing is on the list. We do know that the defense has turned over his curriculum vitae and his report. And I haven't seen a motion to exclude him yet, I don't think. So there's that. All right, there are a couple of new droppings here, but I don't know if they've been scanned. That's the problem with this court. Sometimes they put it in the docket, but it doesn't get scanned in. There's a Commonwealth's motion for a larger screen in the courtroom. Imagine that. All of a sudden, the Commonwealth wants the jury to be able to see their exhibits and their inverted videos that they put up on that screen. Wow. And then there's a defendant's emergency motion for relief from this court's order impounding the clerk's list of jurors. It's allowed. The information is not to be disseminated by anyone. It's for counsel and the defendant only. Okay, so she ruled on that. We're going to go over that motion too. So just get yourself some popcorn or drinks or whatever it is. Gary Fowler of Brockton. Gregory Woodbury. Gretchen Voss. That's going to be a great cross too. Ms. Voss, did you ever do psychedelics with a not-so-confidential informant in the Aidan Kearney case? Hannah Knowles. Heather Maxson. Heriberto Hernandez. He is going to come in and testify about Brian Albert's vicious propensities, violent propensities, because I do not know if he was sucker punched by Brian Albert when he was drunk or if he was a witness to Brian Albert sucker punching someone else. Holly Price of Mountain View, California. I love Mountain View, California. The Grateful Dead used to play there all the time. It was a great venue. I can't remember who Holly Price is. Ian Whiffen is back. He lives in Virginia now. Oh, I thought that maybe that's his office address because, he's Canadian. Irene Scordi-Bello, the chief medical examiner, is here on the list. James Crosby, because of course he should be allowed to testify. Don't let the XBI expert come in and testify about proper police procedure, but let the guy in who's not even a doctor come in and talk about whether or not the injuries to John O'Keefe's arms were caused by a dog, even though he's not a medical doctor. Jason Becker, Canton Fire Department. Jean DeMoulis, I think it's escaping me right now. Jennifer McCabe. Jessica Hyde. John O'Keefe Sr. So John O'Keefe Sr. lives in Braintree. He does not live in Canton. Isn't that where Mrs. O'Keefe, Peggy O'Keefe, lives with the children in Canton at One Meadows? John O'Keefe Sr. lives in Braintree. Just an observation, no judgment. Judson Welcher, Julie Albert, Julie Nagel, Justin Rice. He was the doctor from the ER. Juvenile niece KF from Canton. Juvenile PF, nephew, Canton. Caitlin Boudreau. Oh, I know who that is. That is Nathan Reed's wife. Coincidentally, the case I was telling you about earlier, where perhaps Colleen Crawford and Trooper Fanning have been involved in some video altering, it was alleged anyway, was in the case of Keith Boudreau. Keith Boudreau was the decedent in that case. He was stomped to death by the steel-toe boots of a man named Paul Fahey, allegedly, but it's on surveillance video that may or may not have been proctored by Colleen Crawford and Trooper Fanning. Those are the allegations. I'm just putting out there what's in the court papers. And I don't know how common a name Boudreau is. I don't know that she's related to Keith Boudreau, but How tragic that would be if she was. Karina Kolakithis, one of my favorite witnesses. Katie Camerano, another favorite. Katie McLaughlin, who happened to go to school with a girl named Caitlin Albert. Keeper of records for Ring in Hawthorne, California. Carrie Curran, Carrie Roberts, Kevin Albert, Kevin O'Hara of the Massachusetts State Police, Lance Mello, MSP Crime Lab, Laura Sullivan. Oh, I thought the Sullivan sisters weren't coming in. He's got them on the list. Lori Cahill, Leslie Perlstein, Lieutenant Michael Lank. Okay, so Lieutenant Michael Lank is under L for lieutenant instead of M for Michael. Does this strain credulity at all? For anyone other than me? Louis Jutras, the keeper of the library footage, works for the Department of Public Works, I believe, in Canton. Canton testified during the first trial. Yes, and right, exactly. Bubsy, the bottom line is we will never know exactly how John O'Keefe died. Right, because of the improper investigation, evidence collection, lack of testing unknown samples of DNA, so many things, but apparently they weren't. Those samples of DNA were not suitable for testing. But just a reminder there are two male contributors to the DNA, reddish brown stains on John O'Keefe's clothing that were not tested because apparently they weren't, suitable for testing. Oh, and this is interesting. So Lieutenant Michael Lank, lieutenant is spelled out. So alphabetically, he comes before Louis Jutras. And then Lieutenant Brian Tully is spelled LT, so they're a little further down on the list. So Lieutenant Brian Tully, Lieutenant John Fanning, and Lieutenant Paul Gallagher are all under the L's, but after Lieutenant Michael Lank, and in between is Louis Jutras, because you just can't make this up. You just can't. Maggie Gaffney, Mark Lopalato, who is the brother of Alfredo Lopalato. Peggy O'Keefe lives in Canton. Apparently, O'Keefe Sr. does not. He lives in Braintree. Guess they don't live together anymore. Really, that is not for me to judge. So I will not say a thing. And I'm not inviting anyone in the chat to say a thing either. I'm just pointing it out, is all. Marietta Sullivan is also on the list. She thinks Karen Reed sucks. We heard that during the first trial, but again, thought they weren't calling them. Mary Souza from Dighton. Matthew Armory. Matthew DeSogra. Matthew who's a engineer. Matthew Erickson. Matthew Kelly. Matthew Kelch. Oh yeah, that'll be a great cross-exam. Matt Kelch is the friend of Brian Higgins who let him use the kiosk. Let him use the kiosk in the FBI headquarters so that he could cherry pick the text messages that he wanted to extract from his phone so he could print them all out, Brian Higgins, and bring them with him into his interview with, I don't know, was it Proctor? Stacky says, this list triggers my OCD. It's triggering in so many levels. Matt McCabe, he still lives in Canton. Maureen Hartnett from the Crime Lab. Megan Mariani, New York, New York. Michael Camerano. Michael Easter. Well, apparently not anymore. Michael Trotta. Canton Public Works. Michael Wagner from Foxborough. Mike Maroli. Mike Rushworth. Okay, so some are Mikes and some are Michael. Screws up the alphabetization, but whatevs. Natalie the German. Natalie Y. Wiki Berschneider is going to come in. That's going to be fantastic as well. Can't wait. Can't wait. Nathan Reed is on the list, but they're never going to call him. Nicholas Bradford. Nicholas Curran. Nicholas Kolakithis. Nicole Albert. Okay, wait. So Nicole Albert lives in Norwood. Let's go back to the B's because we don't want all the Alberts in a row. And let's see, where does Brian Albert live? Hold on, I'm curious. Oh, he lives in Norwood too. Well, I don't know if they live together or not, but none of my business. Norfolk County District Attorney Michael Morrissey. Yes, let's put him under N for Norfolk instead of M for Michael, or D for District Attorney, because, nothing makes sense in this upside down world of Narnia. And then we get to the O's. Officer Kelly Deaver of the Boston PD. She used to work, I think, for Canton PD. Officer Nicholas Barros of Dighton PD. Good. We love him. He said the taillight was cracked, but not completely damaged. Patrick Haggerty. Paul Mikowski. Paul O'Keefe lives in Canton. Well, guess Paul and Aaron don't live together anymore because Paul now lives in Canton and Aaron lives in, where did we say that Aaron lives? Braintree? Hold on. West Bridgewater. Oh, well. Who's the tow driver? The tow truck driver, I think, is that Haggerty? You guys can let us know in the chat. I wonder if Paul moved in with his mother at One Meadows. Rebecca Bazin. Rebecca Trayers. Renee Stonebridge, my other favorite witness, the brain doctor who examined John O'Keefe's brains. She's got all the injuries. She's got all of the nuggets in her testimony. She would be a very, very friendly witness for the defense. And hopefully this time she will be meticulously cross-examined because she's got all the answers right there and she's willing to give them. She just needs to be asked the right questions. Richard Green, Ricky D'Antuono, Robert Gilman. Oh, yes, he's the weatherman. Ryan Nagel, Sarah Levinson, Sergeant Brian Gallerani from Needham Police Department, Sergeant Sean Good. So those who are under the S's, keeping track here, that lieutenants are under the L section, officers are under the O section, and Norfolk County District Attorney Michael Morrissey is under the N's section. Because, you can't. And then in some of these, sergeant is spelled out, and then some of them is just SGT. Paul DG Pietro. Well, that's going to be a fun cross-examination. That retired detective from Canton who downloaded all the Sally Port video. None of it has metadata. And then Sergeant Yuri Buchanan, he's in the S column too. Shannon Burgess, I think that's the one, the expert who doesn't know bits from bytes. That'll be interesting. Cheryl Waugh, I think that she may have been bit by Chloe. You can correct me if I'm wrong. Chat. Sophie Hryzen of the Massachusetts State Police Crime Lab, Stephanie Devlin, Stephen Mullaney, Canton PD, Steve Nelson, he's the victim witness advocate, who may or may not have tipped off a couple of guys to destroy their cell phones prior to the preservation order being issued or denied, or who can even keep track at this point? Because, no biggie. Stephen Bernstein, keeper of records, Stephen Ridge, Boston PD, Stephen Saroff, Stephen Scanlon, he's on the list. Terry Kuhn, she's the canine DNA expert out of UC Davis. Tess Chart. Tom Beatty is on the list, as is Tom Kelleher. Tom Kelleher, who lived right across the street from 34 Fairview, was the deputy chief of Canton PD. Not only did he never come out of his house, but he gave them solo cups to collect the blood evidence from the snow. And he also has a Ring camera that points right at the lawn of 34 Fairview. But apparently someone asked him if he had any interesting video footage of the incident, and he said no. And they just took his word for it. So that'll be a fantastic cross as well. I don't know who's going to call him in their case in chief, but I can't wait for it. Thomas Martin of Weymouth, not sure. Timothy Nuttall, I think he's the one who talked about the puffy jacket, and he was convinced that John O'Keefe had a puffy jacket. Right? Was it Nuttall? I think it was Nuttall. He was a little nutty, and we have a puffy jacket emoji just for him. Tristan Morris, the guy who has no idea what time anything happened. He's the know-nothing witness. It'll be interesting if he's called because he adds zero value. He knows nothing about nothing, except for he had to get up at real early in the morning to do some plowing that night, but he went and picked Caitlin Albert up at a time that was not in any sort of witness statement, because they all said Caitlin Albert left at a certain time, like maybe 12:30, but she really didn't leave until Tristan picked her up. And I can't remember what time exactly that was, but she was the last to leave. So there's that. And he, I think, has since married Caitlin Albert. Trooper Connor Keefe. And now these are all under the T section. I know it might freak you out. T. Trooper Connor Keefe. These are all from MSP. Trooper David DeChico. Trooper Evan Brent. Trooper Jeffrey Kakowski. Trooper Joe Paul. Joe Paul's back. Trooper Kathleen Prince. Trooper Michael Proctor. Shouldn't that say ex-trooper or former disgraced, dishonorably discharged Trooper Michael Proctor? But, I'm just being picky. Trooper Nicholas Garino. Trooper Zachary Clark, all in the T's. Then we have Wendell Robery of Canton. Mr. Reed. They are never going to call Bill Reed. And if they do, I hope they get what they deserve with his testimony. Please note that the defense has not included the following names, which were included on the Commonwealth's prospective witness list: Alan Jackson, Esquire, David Unetti, Esquire, and Elizabeth Little, Esquire. Defendant objects to the inclusion of Ms. Reed's attorneys on the witness list. This request is not made in good faith. Well, that's putting it mildly and very kindly. If the Commonwealth subpoenaed defense counsel in this case, it would constitute a gross violation of the Rules of Professional Conduct 3.8, which prohibits prosecutors from subpoenaing a lawyer in a criminal proceeding to present evidence about a past or present client, absent exceptional circumstances. Call that a very nice, fair warning from the defense team to Hank Brennan, the prosector in this case. The list is comprised of 150 total witnesses. And I don't think I saw Karen's mom on that list, right? Maybe they decided not to put her on the list, because I think on their amended witness list, they did have Janet Reed on the list, but I'll have to go back to the J section. And if it's not in the J's, I'll have to maybe check the M section for Mother Janet Reed. No, I guess they decided they were going to take her off, right? Thank you very much. That's an excellent comment, CJ, and you deserve to be highlighted for this. This list reflects the way the police handled the crime scene. Well done. Well done. Yeah, so there's that, 150 witnesses. Do you think this trial is going to be any shorter than the last? I don't think so. They're saying they had to hire out. They had to get a hired gun, Hank Brennan, to come in and try this case because it's the hot potato case in Norfolk County. Lucky is on the list. His name is Brian. Yes, Brian Loughran. He was one of the many Brians that we talked about at the beginning. Brian Albert Jr., Brian Higgins, Brian Laughlin, and Brian Wanless. Lots of Brians. Apparently, if you live in Canton or nearby or in Norfolk County and you don't know a man's name, call him Brian and you'll have a 50% chance of getting it right. It's going to be longer, Scott McGinnis. I agree. The chat is split. Some say longer, some say shorter. Let's go back to the chat. Then we have so many documents to look at, but we have to keep up with these questions. Otherwise, it's going to be very long later on. Ann Bozzarelli has been here for 17 months. Ann Bozzarelli is an OG. And it's been really fun. 17 months. 4 words: recuse, Bev, do it. Well done, Ann Bozzarelli. Love you, girl. Shannon says, little Hanky, the Xmas poop makes me sick. The judge and prosecution team are so corrupt and biased. How is this okay? I'm embarrassed to live here. That's rhetorical. So I don't think you're looking for an answer from me, because you know what it's going to be. Thanks, Shannon. Lamassus, can't the defense get copies of police reports done by others and ask them why there are differences? Bev is sitting on the scales of justice. Yes, and she's weighing heavily in favor of the prosecution. Thank you, Suze, for your suggestion. Paul, can see why Allie McCabe is not on the prosecution list. Well, she's on the list. This is the combined list, though. She was on the defense list. Thank you, Paul. Kim, thanks for the 10. If Reed's team didn't get the autopsy photos until May, and realized the dog bites on his arm. How did Scanlon know to mention the dog bites on his arm just days after the incident? Right. But apparently Scanlon may have walked his testimony back. That Kim is something that a lot of people have pointed out. How did he know the details of this that other people didn't know, that weren't publicly available, unless he really did have some information? You're right, Kim, you're right. Will he come in and tell the truth and do the right thing? Time will tell. Cannoni's baloney. Judge Sisitsky needs to tell Bev how she's coming off. Thank you, Dave Barry, for your super sticker. Yes, they're in separate towns, Laura. Aaron and Paula Keefe are in separate towns, but we are not here to discuss anyone else's marriage in the chat because we try and keep it classy because you never know who's watching. And by the way, I say that because in the Turk trial that we're covering, that is happening in the courtroom next door to the Karen Reed jury selection, which will be happening tomorrow. That judge is Judge Mark Halal. He has told the jury in his case, in Dr. Turk's case, that they are not to do any outside investigation, not only in the Turk case, but also in the Karen Reed case. And the reason for that is because several of these troopers are involved also in Turk's investigation. Tully, Fanning, Buchanan, Proctor, who the Commonwealth said they're not going to call, Garino, and many others. And that's the reason for that instruction. And that happened in 2020. Anyway, in that trial, we are watching that trial together. And the victim, her name is Katie McLean, may she rest in peace, was strangled by Dr. Ingolf Turk, who reminds many of us of Dolph Lundgren. You may know who that is. He's an enormous man who's a robotic surgeon, a urologist, whose face was on billboards near, I think it was Brighton, the hospital that he worked at. Katie McLean is the victim in that case, and her daughter has been watching our coverage, and she comes in and she comments and she says, "Thank you so much for covering my mom's case. And it is very sad and very tragic. And you never know who's watching, which is why we keep the chat classy. Rumor and speculation, bashing people's personal issues, not allowed." Thank you so very much for being here. I love each and every one of you. Abacus Flinch, want to go over the latest Better letter from the past Saturday? Yes, we have it. We have it. I'm going to write that down. I may do a separate stream because that technically is on the Aidan Kearney case. And so I have separate playlists for this and that. And I have so many documents on this that I think I want to do a separate stream on that to keep them separate. But thanks for your suggestion, even though I already had a thought of it in my head. Nothing to see here with all the cops and MSP on the prosecution side. Can't the defense then bring in procedures of preserving a crime scene? Well, that's what we're talking about. That's what we're talking about, but who? So I think an expert should be allowed. I think it's invaluable testimony because I don't think a jury understands. Just because they've watched Law and Order, they don't understand how a crime scene is supposed to be run. Liberty and Justice for All trial in Massachusetts is like a box of chocolates. You never know what you get. Thank you. Thank you for thanking me. Scooter, what's the process behind calling witnesses hostile? Well, that would take an entire stream to go over that. And so we are not, there's nobody that was listed as a hostile witness on there. But when you are cross-examining someone or when you are direct examining someone, if they start to be what the court determines is hostile, then it gives you greater latitude in perhaps using leading questions and things such as like that. And so it is something that we could do an entire stream on. However, that is it sort of in a nutshell. You have to ask permission to treat the witness as hostile. For example, if you call somebody on your case in chief, that is really a witness that is against your case, and then they start acting hostile on the stand, you're given sometimes more latitude. But in this case, would she ever give anybody more latitude for anything? No, not if it doesn't favor the Commonwealth, in my opinion. Kelly, I have noticed that Judge Kearney has ruled against all of Alessi's motions. Have you noticed this? No, I have not. Because I thought Alessi won at least one or two. I'd have to go back and make a chart or at least notes on that, Kelly, but I have not noticed that. Thank you so much for your 10. Bite my bits. You see Brennan was involved with, no, I did not see that. And I'm, again, the rumor and speculation, I won't even read it out loud, but thanks for your $2. Andrew, thanks for tuning in from Australia. Plan was to set up Lucky. Higgins went to the Sally Port to find out when the snowplows would start. 2:30 a.m. 2:27 a.m. Haas Long to Dying Cold was searched. Consciousness of guilt. Forward edge comes out after the first pass was witnessed, and then the body. That's an interesting theory. A lot of people think that. And, I pointed that out. Thanks for tuning in from Australia, first of all, Andrew, and for your super chat. Pointed that out during Lucky Loughran's testimony. And I said, isn't it wild that I thought perhaps the original plan was to make Lucky the fall guy? And Lucky was, he's known the Albert family since childhood. He was being considerate of them. He didn't want to plow the forward edge in, and he also didn't call to get it towed because he thought he was doing them a favor. Kansas SOFA juror, can they call the chief of MSP and ask him to point out in the policy manual where it indicates users? Again, he's not on the witness list. We're up. All the witness lists were exchanged, and we could sit here and hypothesize all day about things that maybe they could do, maybe they can't do, but I don't think it's the best use of. I mean, it's a great question. Again, there may be other ways of getting the policy and procedure in, but the chief of the MSP is not on their list. And so at this point, it would be a late exchange. I don't think she would allow it in. But again, ask the magic 8-ball. Leap blower, stop and shop bags are acceptable use in investigation. They're gonna say, listen, we did the best we could under the circumstances. That's why they need an expert, right? Thank you, Kansas Sofa, for pointing that out. Canoni's baloney. Can the defense demand the metadata for the new enhanced ring video? I think Brennan showed in court the other day to compare and see what exactly was done to it. They can demand lots of things. The judge doesn't seem to think that metadata is important here. I think a lot of these questions are rhetorical, so I'm just going to read them out. Michelle, thanks for your 10. So you're asking the cops who didn't do a proper investigation how to do a proper investigation. Make that make sense? Again, right. And are they going to tell the truth? No, of course not. They're going to make excuses for their piss poor investigation, just like Proctor got on the stand and made excuses for his disgusting text messages. Oh, it was unprofessional and improper of me to do that. But, emotions were running high. No. They got a lot of problems, the Commonwealth. Proctor's been terminated. But, the judge keeps giving them freebies. Here's a bone. Throwing the Commonwealth a bone. Lots of bones. It's because Colin knew Proctor. I don't have any knowledge of whether Colin knew Proctor. This adventurous book mouse, I can't confirm or deny. So I don't know. Proctor is on the list. He's under the lieutenant section, I think, or the T for trooper section. This is not, Cindy. It doesn't. Sorry, it's not alphabetical. It's just, he's in the T for trooper section. That's where. Hank is on one with his continued filings 657, 658 waiting. I've got up to 655. Let me refresh my browser. Because they're dropping like it's hot, Eva trial, dropping like it's hot. This case is going tomorrow, hell or high water. All right. Well, here's what's dropped. I don't know the physical documents, but since the last time I refreshed my browser, and when we talked about the Commonwealth's motion for a larger screen in the courtroom, Commonwealth has made a motion for parameters of jury impanelment. Commonwealth's motion to impound, exhibit, and support a Commonwealth's motion to compel reciprocal discovery of ARCA witnesses or to exclude their testimonies. And a Commonwealth's renewed motion in limine to exclude expert testimony of Garrett Wing. That is docket number 658. Dropping like they're hot. Okay. It's hard to stay on topic, I know, but that's why we try and do this with all the questions in order so that we, when I go back to these questions, we're not on a totally different subject. Who is Thomas Martin? I don't know, good Norfolk County citizen. Maybe somebody knows. Thanks for being with me for 5 months. Doesn't ring a bell with me right now. But a lot of these people, Aidan Kearney has reported on. So sometimes if you Google the name and then put Turtle Boy next to it, it'll come up in one of his older articles, or as they like to call them, blogs, because he's just a blogger. McBev's Inferno Divine Comedy, 9 Circles of Hell, became a YouTube member. Thank you so much for joining. Canadian Gooner depends on Baloney's days off. for questions. I don't know. Thank you for your Canadian too. The Canadian Deuce. Hey, D&E Pizza Duck. Didn't know I had that much faith in the system to lose. Thanks for being here for 6 months, girl. Wait, does this mean that Mr. Reed can't be in the courtroom? No, they have agreed, both sides have agreed that the family members of John O'Keefe and the family members of Karen Reed would be exempt from, I believe, the sequestration order. Yeah? So he can be. Kelly, why so many witnesses from recused Canton PD? Says no shock on the rulings or timing. Her ruling on dismissal said trooper, not ex-trooper Proctor, so it was obviously written long before it was released. Well, there you go. Except for this is the combined witness list. So I'm just thinking whoever typed up this witness list didn't put in the preface to Trooper Michael Proctor's now disgraced name. Thank you, Kelly, for pointing that out. Bashing Bev aloud, please. Let's try not to be defamatory. If you're going to say something, just say, in my opinion. That would probably make it okay. But, Mish, thank you for your super sticker. Love my flip-flops. Thanks for hanging out for 3 months. Says, so many lost moral compasses in Canton. The rehome Sallyport camera is here and says, I would make that a juror question. Do you know the standard operating procedure for police officers in this jurisdiction and other jurisdictions and why they exist? That's a great point. The jury questionnaire has already been completed, I think, and approved by the court. But based on this new ruling about Easter, that is a great point. Thank you for pointing that out. And hopefully, if the defense team is watching, maybe they can use that. I don't know. I don't know that the attorneys are going to have much say in the jury selection. I don't know what the hell goes on there. I've pointed out several times in New York here in civil court, I'm a civil litigator and I've been around the block and I've got decades of experience. And in civil cases, oftentimes the judge is never even seen during jury selection. And we pick our own jury and we do our own thing. And it's like, come back when you're done. Criminal court here is a bit different. But again, the attorneys have wider latitude than they seem to have in Norfolk County, Massachusetts. Piney Woods is here. Thanks for the 20. Says, I can no longer defend Bev, period. Her bolstering Commonwealth witnesses over and over is battering Ms. Reed's procedural and substantive due process rights. In my opinion, she's dirty. Ask for leave to file second motion to recuse. I will grant that motion. Piney Woods is also, I believe, an attorney. So he knows what he's talking about. Canoni's baloney, Jazzia. It says, Bev's not just sitting on the scales of justice. She's swinging on them like they're hung on the porch of her cottage on the Cape. Well done, girl. Well done. I'll allow it. She's swinging from it like it's the chandelier. Ashley, can defense still get the investigation testimony from Easter? They need, just not as a qualified expert. No, I don't think he's not going to be allowed to testify at all because what else would he's not a fact witness. He wasn't there. He didn't take part in the investigation at all. And so the answer to that is no. Sorry. Thanks, Ashley. Fire on acid. We all feel it. Are you worried based on the rulings? Am I worried? No. I have full faith and confidence in the defense team. They are professional. They will find their way around this. But what I'm worried about is the justice system in the state of Massachusetts. That's what I'm worried about. I'm not worried about Karen Reed getting a trial that she can be acquitted. I believe she'll be acquitted, or I believe there'll be a hung jury. I don't think there's any way in hell she's ever going to get convicted. If it's a mistrial again, if it's a hung jury again, are they going to retry her? Probably. We've seen other cases where they retry defendants 3 and 4 times in Massachusetts. So no, I'm not worried, but I can see how you would be, and I'm here to tell you to calm down. Calm down. Everybody come back off the ledge. Come back off the ledge, all of you. Calm, children. Come. It's going to be fine. It's going to be fine. But again, she's putting on full display her bias, in my opinion. This is unlike any other court system, jurisdiction, place where real trials happen. This is the land of make-believe. Kelly, why so many witnesses from the recused Canton PD? Breenan's obsessed with ARCA. He's trying everything. Yes, because ARCA kills his case. They kill his case. Thinks they're biased. But, the thing is, physics They don't need to be biased to talk about physics because physics don't change, right? They don't change. Wow. All right, let's see if anything new has popped into the inbox while we're here. Not yet. Okay, so let's take a look at the next most interesting thing, in my opinion, that we did not cover from last week, and that is, I have notes today. Hang on a second. And they are written in purple Sharpie because every girl needs a Sharpie. Docket number 643. This to me is wild, and good luck with this. Oh, 643. Let me pull it up. You can't have too many tabs open, or StreamYard crashes. This is the Commonwealth's pretrial memorandum. And this was filed. Let's see when this was filed. 643. All the way back on the 28th of March. It was only Friday. Wow. Wow. All right, here we go. This is the Commonwealth's pretrial memorandum. And they start off by setting forth their proposed statement of facts to the jury. Well, I think Judge Kearney just gave you a whole bunch more facts in her order regarding third-party culprit. Wow. True crime plus scrapping. This was a good question, so I put it up. People say, oh, Melanie only answers questions through super chats or members. And it's so not true. When I see an interesting question fly by, I stop what I'm doing and I answer it. It says, why are the law tubers so confident that she won't be convicted? I feel like they know something more. No, I don't think anybody knows anything more, but I'm going to tell you my thoughts on this. Turtle Boy and I cannot remember who else both intimated there is an ace in the hole. No, I don't. That's not what I'm saying. I'm saying this. Here's what I'm saying. First of all, there's nobody in the entire county of Massachusetts, entire county of Norfolk, I submit to you, that has not heard about this case. They're calling in how many jurors tomorrow? 150, 200 or something like that? People, whether they know it or not, have already formulated opinions on this case. The question is, can you be fair? And can you put those opinions aside? And, they're going to try and find people who don't have opinions. But you can see it based on the division in the people who feel like Karen Read is guilty and should be stoned to death before she's hung in town square and absolutely did it with her car or for whatever ulterior motive, that they don't like the looks on her face. They don't like the way she looks at her parents. For whatever reason, they think she's guilty. And then there are the people who believe that John O'Keefe was not hit by a car. Okay? People on either side of that divisive, I don't know. People on either side are never going to be able to convince the other people that they're right or that the other person is wrong. I mean, you see it. And so if there is one person who thinks that John O'Keefe was not hit by a car, no matter what the other people say, they are never going to be able to convince them of that fact. And that's really how simple this case is. Was John O'Keefe hit by a car? Yes or no? If he was not hit by a car, we all go home. We're done here. Vinnie Politan was on my show, and he said he thinks they will never, ever convict on first degree or at second degree, that it was overcharged. Manslaughter, he's not so sure. And he said he comes into the case with very personal bias, that his neighbor's entire family was killed by a drunk driver when he was young, and he has very strong opinions about drunk driving. And Karen has admitted in her latest documentary to having 6 drinks. There are people who will not be able to get past that. People on the jury who said, well, Karen was there. and John was there, and she was the last one who saw him, and she was drunk, and he was drunk, so therefore she must have done it. That's why I don't think there will ever be a conviction. I don't think 12 people will ever agree that John O'Keefe was hit by a car. And so it's not that there's an ace in the hole or that I have any special knowledge, and I don't. And when people send me emails and they're like, you need to forward this to the defense, please understand, I do not have a direct line to the defense team. I am not part of the defense team. And also, I do not send them anything. I have nothing to do with the defense team. So please don't send me emails telling me to send things to the defense team or to send things to other YouTubers. I'm not your secretary. And I also do not work for the defense. And I'm here sharing my own opinions about this case. Some moron on Twitter is out there defaming me again, and other YouTubers as being paid to spin the narrative of the Karen Reed trial. No, these are my opinions. I came into this case not knowing who Turtle Boy was, never covering anything about Turtle Boy or his case until it became inextricably intertwined. In fact, the word turtle was banned from my chat. And that's why Turtle Boy thought he was blocked from my channel, because his name is Turtle Boy Live. Turtle was blocked from the chat because I didn't want to get sidetracked. I wanted people to come in here and have a place to learn about the Karen Reed case, people who didn't know about Turtle Boy, and there are people out there who just hate Turtle Boy, and that's the reason that they think Karen Reed is guilty. And in my opinion, that's not a good enough reason. So there's that. My opinions are my own, based on my own decades of experience as a lawyer, handling not only thousands of car accident cases, but also dog bite cases, from hiring hundreds of accident reconstruction experts to reconstruct accidents such as this, products liability cases, medical malpractice cases, all on the plaintiff side, products liability, medical malpractice. I sued the Catholic Church for the victims and survivors of clergy SA. So if you people on Twitter think you're going to try and scare me away from reporting on my opinions of the Karen Reed case, you got another thing coming. I do not work for Karen Reed. I do not work for the defense team. I am not paid to share my opinions. These are my opinions. Cry about it. Here's the proposed statements of facts to the jury. This is the Commonwealth's pretrial memorandum. Sorry about my side rant. On the morning of January 29th of 2022, at approximately 6:04 a.m., the Canton Police Department received a 911 call reporting an unresponsive male party in the snow outside a residence at 34 Fairview Road within their town. Let me recreate that call for you. There's a man passed out in the snow. That was Jennifer McCabe. The call didn't say officer down. My dear friend, Boston police officer John O'Keefe is on the front lawn of my sister's house. Come quick. No. There's a man passed out in the snow. Don't tell me what to waste time on acknowledging people like that. It's not about acknowledging people like that. It's about telling everyone that these opinions are mine and that I do not work for anybody, and also do not ask me to forward things to the defense team or anyone. And in fact, I am not your secretary. It is not so much a calling out of trolls as it is telling everyone who may be new here that these are my opinions and I actually have a brain. And so do the many, many other people who do not think that John O'Keefe was hit by a car. Brains, common sense. Officers responded and discovered the male party, subsequently identified as John O'Keefe, off the roadway in the front lawn area. See, they keep changing his location. Now he's off the roadway. In some earlier filings, they said, when Hank Brennan got involved, alongside the roadway, right? I think when Lally had the case, it was like 30 feet onto the front lawn. And they say Karen Reed's theory is changing. Officers identified 3 women with Mr. O'Keefe, one of whom was the defendant, Karen Reed, the girlfriend of Mr. O'Keefe. The defendant had been with Mr. O'Keefe the previous evening at 2 different bars in Canton and had driven with them to this residence in the early morning hours of this date. Mr. O'Keefe was treated by paramedics from the Canton Fire Department and transported to the Good Samaritan Medical Center, where he was subsequently pronounced deceased. The Commonwealth alleges that the defendant struck Mr. O'Keefe with her vehicle earlier that morning. See how they're not putting a time on it? And then left the scene while Mr. O'Keefe lay injured in the snow during a blizzard. The defendant denies that she has committed any crimes. They're not putting a time on it. Remember in Lally's opening during the first trial, he said that Karen Reed hit John O'Keefe with her car at 12:45 a.m. By closing, he had to change that. He had to walk that back. And I think by closing, it was something like 12:30. But we know Karen Reed connected to the Wi-Fi and One Meadows at something like 12:36. Yeah, the time keeps changing. So they're not committing to anything. Here are the proposed stipulations. So these are all of the things, I'm going to laugh my way through this, that Hank Brennan is asking the defendants to just agree to so that he can just get evidence in without having to lay foundation or call witnesses. And this is just the audacity. So here are the proposed stipulations from Hank Brennan. The Commonwealth proposes the following stipulations to be entered as evidence at trial. Number 1, in lieu of testimony by the keepers of records for different institutions where the Commonwealth obtained surveillance videos, the defendant agrees to the authenticity of each video. Really? Really? You want, after all of the shenanigans and inverted video and lack of metadata for all of the video surveillance footage that you have provided, you think there's any snowball's chance in hell, there's any chance in hell that the defense attorneys are going to agree to authenticate each video that you want to introduce into evidence instead of you having to call a witness to authenticate the video? That's hilarious. Really? Okay. And then they want, in lieu of testimony by the keepers of records for C.F. McCarthy's and Waterfall Bar and Grill, the defendant agrees to the authenticity of restaurant receipts. Nope. How about nope? Bring in a witness. Say that this was John O'Keefe's bill, that was Karen Reed's bill. No, we're not agreeing. How about this? After the shenanigans that this guy has been pulling since he became the attorney, the hired gun for this case, all the things that he said he was going to do to ensure that Karen Reed gets a fair trial. Yeah, no. How about no? No courtesies will be given because none have been given to the defense team. Number 3, in lieu of testimony by the keepers of records and in lieu of testimony from any defense counsels, the defendant agrees to the authenticity of her audio. The defendant agrees to the authenticity of her audio and video recorded statements made during interviews with reporter Gretchen Voss, Boston Magazine, audio only, reporter Matt Gutman, ABC News, reporter Dennis Murphy, NBC, and reporter Ted Daniels, Boston 25. How about no? How about you put each one of those reporters on the stand to authenticate their video? How about that? So that they can be questioned. How about that? No. This stipulation also includes any recorded statements made by the defendant to ABC, including ABC News 2020, Karen Reed, The Perfect Storm, Good Morning America, NBC Universal, including Dateline, The Night of the Nor'easter, and any statements of the defendant to Terry Murer of Unsolved Productions. Yes, that was the 5-parter. Or appearing in a body in the snow, the trial of Karen Reed, appearing on Investigation Discovery /HBO Max. Yeah, no. How about you prove your case like a real trial lawyer and call real witnesses to authenticate your evidence? No. How about no? Yeah, exactly. Grace Bass says, can't wait for the defense to tell Hank where he can shove his proposed stipulations. This is just the audacity to even ask, though, right? Number 4, in lieu of testimony by the keeper of records, the defendant agrees to the authenticity of statements attributed to her in a 2-part Vanity Fair article entitled Karen Reed Tells Her Story, A Murder Trial in Massachusetts by Julie Miller, published on October 29th, 2024 and October 30th, 2020. No. Nope. Sorry. Won't agree to that one either. Try your case like a real lawyer. Call actual witnesses that can authenticate your evidence and like lay a foundation for this stuff coming in. We're just not going to agree to it to make your job easier. Wayne says, no, Spanky, you can go sit on your special bench in hell. Go sit on your special bench in hell. Not Eminem's mom says, agree to authenticity of audio and video. Nope, both can be edited, right? And nothing's got metadata. And how about no? In lieu of testimony by the keeper of records, the defendant agrees to the authenticity of William Reed, Janet Reed, and Nathan Reed's recorded statements, audio and visual, to Ted Daniels and Boston 25. Well, if you're going to have Ted Daniels on the stand anyway, you can kill 2 birds with 1 stone, as it were, right? Number 6, the parties agree that the known DNA standard for John O'Keefe may be admitted without testimony from the forensic scientist, Ms. Sophie Horizon, that created the standard. Yeah, I'm sorry. No, no, we're not going to give you that one either. Ain't going to be no mulligans for you, Spanky. The parties also agree that the standard may be used and referenced by analysts from the MSP Crime Lab, Bodie, and UC Davis Veterinary Genetics Lab when they testify to their work, analysis, and conclusions based on samples in this matter, including making statistical opinions based on the standard for John O'Keefe. I'm sorry. What? The known DNA standard for John O'Keefe. Maybe how about you prove it first? How about that? Because based on the way that you guys have handled all of the evidence in this case, I don't think anybody can be trusted. How about you? Number 7, in lieu of the testimony by the keeper of records, the defendant agrees to the authenticity of her medical treatment records and the medical treatment records of John O'Keefe and the admissibility of such records subject to appropriate redaction. No, absolutely not. Absolutely no. Because those doctors who made notes and the nurses perhaps who made notes into those records need to be questioned about their notes, because oftentimes, you may know, if you've ever requested your own hospital record or your own emergency room record, or if you've worked in the business of, plaintiff's litigation ever, you have no control over what the medical provider writes in their notes. You may not have said that. You may not have told them that. And still it appears in the medical records. And so therefore, the answer is no. Number 8, in lieu of testimony by the keeper of records. Oh, so maybe they're just talking about the keeper of records, but I would still say no. Force them to bring in every single witness necessary to authenticate any of this stuff. In lieu of testimony by the keeper of records, the defendant agrees to the authenticity of reports generated by the Canton Fire Department. No. Nope. I don't think so. Number 9, in lieu of testimony from Andy Klein and Mike Maroli, the defendant stipulates that on September 23rd of 2024, Aperture inspected, photographed, measured, and laser scanned the defendant's 2021 Lexus LX 570, John O'Keefe's 2019 Chevy Traverse, and area outside of 34 Fairview Road, Canton, Mass. On October 2nd, 2024, the driveway and surrounding area of One Meadows, Canton, Mass. were photographed and laser scanned. No, I'm sorry. You're going to have to bring them in. You're going to have to bring them in because they're going to have to testify, about their methodology and stuff. And, note also the dates that this was done after the first trial. They were hired by the Commonwealth after the first trial to go to One Meadows and laser scan that driveway. Why? Because they want to try and prove that Karen Reed's car did not even hit John O'Keefe's car that was parked in the driveway. And certainly, absolutely no way in hell did she crack her taillight that way. And so, no, you're going to have to actually call your witnesses. So sad. Too bad. That's how real trial lawyers try their cases. Additionally, the Commonwealth proposes 10, when questioning witnesses for uniformity and efficiency, The parties agree to use the transcripts from the prior trial that do not contain the sidebar conversations. I mean, I don't know why that would be important to them, because maybe just the transcript is shorter and there are less pages, because they're not going to use the transcripts from the prior trial unless they're trying to impeach someone. So, but you know what? All of his requests just are shady to me. So I would just say no to everything, including number 10. Respectfully submitted for the Commonwealth XOXO, Michael Marcy, District Attorney Hank Brennan, Specially Appointed District Attorney Adam Lally. They have found a new font for signatures, and Laura McLaughlin. Dated March 28th, 2025, which was Friday. I mean, I was only gone. Like, I did not stream for only one day, and that was Friday, and there's so much that has happened since then. So I thought that was kind of funny, that he would just expect that, yeah, sure, no big whoop. Yeah, sure, we'll just agree to all of that stuff. We'll just, you might actually have to do some real lawyering if we don't stipulate this stuff. So, oops. That was docket number 643. We went over the combined witness list. We went over the order on Michael Easter. We went over the order on third-party culprit. Let's take a look and see if anything new has hit the inbox. Hold on. Nothing yet. Let's go back to the chat. There's a lot of questions here. I'm just going to see where we left off. Hang on a second. Piney Woods is back. Thank you with another 20. I have had biased judges before. A good trial lawyer can deal with these. Yes, yes. Bev's gone beyond bias and straight into being a fourth prosecutor for the Commonwealth. In 30 plus years, never seen anything like this. Thank God for defense counsel. Yeah, I got to agree with you. Unidentified co-conspirator. Thank you so much, Piney Woods, for your 20. Bev has destroyed her legacy. I know. Is this really the hill that she wants to die on? I've been saying that for a while. Misty, is it too late for the defense to call a different Bowden expert, as in the great retired MSP Todd McGee? No, I don't. Yeah, I think it's too late. But also, why would she let him in if she's not going to let Easter in? Easter has a lot of experience. I love Todd McGee. I think he's fantastic. I'd love to have him on my show. If anybody has a line to Todd McGee, call me. I think he's lovely, and I think he makes a lot of sense, and I think he's not afraid to speak out about how shitty this. How bad this investigation was. I'm sorry, kids. Earmuffs. But it is too late, and I don't. If she wouldn't let the other expert testify, why would she let him testify? There's no rhyme or reason to it. Virginia, if she goes back to deny ARCA, she is the entire fix at this point. Canadian Gooner, thank you for tuning in from Canada. Why is she not sitting 5 days? Cannot speculate about medical reasons. What the duck? This case should be more important than stuff she has to do. Why is she not sitting 5 days? Are you talking about the judge? Is jury selection not happening every day this week? I didn't know that. If that's true, then I don't know if you guys in the chat can tell me. I don't know. I don't know what you're asking. Is jury selection not Tuesday, Wednesday, Thursday, Friday? Anybody know? Weasel's identity crisis. Thank you for the. I am so mad I could flip a table right now. That's a Housewives reference. I bet Karen and her team feel it worse than we are. Yeah, but they're just going to keep on keeping on, because that's what you do. Thank you so much for your super chat. Suze, I just found my complete copy of the MSP policies and procedures, all 510 pages. Maybe this needs to go on a flash drive. Look, don't send it to me to send to anybody, but I'm sure that the defense has it or knows how to get it. But it's great that you have it. I don't know what revision it is. I don't know when it's been revised. I can't really opine on that, but thank you so much for your super chat. Pin it on Proctor says, I believe none of you. I stipulated nothing. Right, Proctor. Marcello is here from Argentina and says, I started this trial around the time Brian Higgins' testimony. Didn't know who Turtle Boy was when Jen McCabe name dropped him. Oh, interesting. No offense to Turtle Boy, but I thought it was a child on YouTube because who names themselves Turtle Boy. Love him though. There's some, I don't know the backstory behind the name Turtle Boy. I think isn't there a statue of a Turtle Boy? I don't know. I really don't know, but Marcello loves him and there's no shade there. Thank you, Marcello. And for the world is watching. Marcello's in Argentina. He's been with me since the first trial. So I know that he's been here for a long time. Helena, please tell me the FBI can fix this clown show. I have no insider knowledge as to whether they are, I'm not going to lie to you. I have no idea whether they're done with their investigation or not, whether anybody even knows that to be true, but can't yes you to death, Helena. Nina, how can you prevent planted jurors if only the judge can voir dire the potential jurors? Bev clearly wants a pro-Commonwealth jury. Sounds like Nina is also watching from Europe, and she too is horrified, and I think that's rhetorical. Jessica, the metadata says no. I don't know what those emojis are because they don't show up on the StreamYard, but thank you for super chat, Jessica. Reed's bite is bigger than Chloe's says, I believe Clean, who is listed, Klane, Klane, who is listed at number 9 on that, and also on the Commonwealth list, is from Aperture, is the former MSP or tribe trooper who also trained Trooper Paul. That's interesting. That is interesting. Thank you. Julie, can you ask Alessi to check my email from yesterday and get me a coffee? Thanks. Thanks, Julie. Right after I forward all of your messages to the Glara and other people. Can you get this to Bettero? Can you get this to Bettero? No, I can't. Can you give me Bettero's phone? No, I can't. I can't. Reed's bite is bigger than Chloe's. Clean. Yes, I kind of figured out what you're trying to say. I was picking up what you were laying down. Thank you. Nina says, off topic, but any news on Birchmore? I haven't heard anything. I don't know about any hearings or court. I try and have Matthew Farwell's stuff in my own personal calendar. And so I will check Pacer later, but I don't think anything has been happening. He's waived, I think. That's the second time today. That was Melanie Little's left swipe in StreamYard that takes me right out of the stream second time today. I don't know. My fingers are a little sticky. Sticky fingers. It's Rolling Stones album, for those of you who don't know. Swipe left. I don't even know what that means. Okay. So where were we? There's that. Whatever that was that we were just talking about. Where are we? We were talking about Birchmore. Yes. So Matthew Farwell, I'll have to get into Pacer later and see when the next dates are. If anybody knows in the chat, you can certainly, absolutely put it in the chat. I will allow it. Adjust your robe, Bev. Your bias is showing. Well done, girl. Well done. Tuning in from, I'm not sure where, but says somewhere outside the U.S. The fix is in. It is shocking. The rulings coming out from Bev not giving her the judge title anymore. She's lost that privilege. The world is watching. What else would you like to go over from last week, my friends? Let us see. As we wait for that other motion to come in, if it does, because what time is it right now? It's after 5 on the East Coast. It should have been scanned in by now. Because they don't like to work late over there. Those were euros. I couldn't really see the, I know, but that doesn't tell me what country, right? Right, exactly. So somewhere in Europe. I got that much. Out of it. Yes. What a long, strange trip it's been. And Grace Bay says, can we get a swiper emoji? Swiper, no swiping. Maybe. We may have to. Yesterday, there was a nationwide standout. I don't have a lot of information on that, but I think there were a lot of successful standouts for Karen Reed throughout the country, including in other states. As such, you can put it in the chat what happened because I've been off the grid, as I said. I think I addressed all these, but if I didn't, let's just thank Double Trouble 247. Thank you so much. I think we addressed that. And Riley, I think we addressed that. And Stina G, I think we addressed that one. And Kelly, we addressed that. Sarah Berger, can they add 2 questions of the other witnesses that dig out the same information, right? And I don't remember exactly. I asked you what you were trying to get at. I don't know that I got an answer to that. Why is Bettero writing letters instead of motions? That is because that is another way to get discovery without wasting the court's time, is trying to work it out with the other attorney. It's perfectly acceptable. And why should he be forced to make a motion when this is, he's asking him to turn over? And again, that's getting into Aidan Kearney's case. So I wasn't going to segue into that right now, Nina, but it is a way of getting the other side to cooperate with you and to hand over things that they're supposed to be handing over automatically under the rules of discovery that they haven't handed over yet. The next step, I'm sure, once they don't turn it over again, will be a motion. Right? Lucid Visionary Girl says, one way or another, this darkness got to give. Yeah, Grateful Dead, praying for miracles. Thanks for your 5. I agree. All right. Also from last week, let's see what we have here. Well, today, another order dropped about the stenographer. Let's take a look at that quickly. That's 648. Docket 648. Haven't looked at this one either, but it's only 2 pages, so we should be able to get through this. This is the Memorandum of Decision and Order on Commonwealth's motion to appoint a court stenographer, prevent identification of jurors, and impound jurors' names during trial. The Commonwealth has moved for the court to, number 1, appoint a stenographer, number 2, impound the names of all jurors, 3, impound all sidebar conferences, and 4, prohibit spectators and journalists from attempting to provide specific identifying information of jurors or potential jurors to the public. Number 1, a court reporter has been ordered and will be responsible for the entire trial record. Though the courtroom proceedings are recorded on the court's recording system for the record, or FTR, the sidebar conferences will not be available on FTR until after the trial has concluded. Wow. Let us also hide this information from the public, because it was pointed out by Hank Brennan that anyone in the public can get an FTR account and get the daily transcripts of the sidebars. But you know what? The public shouldn't know anything. Hey, Judge Gull, hold my white claw, says Kearney. Check out what I'm going to do. Number 2, this case has garnered significant and divisive attention in Massachusetts and across the country. Well, really across the world. Individuals associated with this case have been charged with intimidation, which charges remain pending. Yes, Aidan Kearney. Guess, how do you not say the out loud part? At least one deliberating juror from the first trial submitted an affidavit to the court detailing reasonable fear for the safety of their family should the list of jurors be made available to the public. I agree. This court concludes that the fear expressed by that juror, coupled with the inordinate amount of public attention to this trial and its outcome, is good cause to impound the clerk's list of jurors for Norfolk County Courthouse for the duration of impoundment. I'm going to have to agree with that. Further, this court concludes that good cause exists to impound the list of seated jurors until at least the conclusion of this trial. I mean, she gives more reasoning for that than for some of her other asinine rulings. And that's kind of an obvious one. Like, yeah, let's protect the jurors. Let's keep their identities secret, private, until after the trial is over, because we don't want them to come to harm's way. And there's a lot of whack jobs out there. According to Michael Proctor. In fact, He called his own medical examiner, Irene Scortibello, a whack job at one point, didn't she? Number 3, sidebar conferences will not be available on FTR. Right, of course not. You just said they weren't going to be available to the public, and so now they're not going to be available on FTR at all. Okay. Or did she just want to say it twice? Like Beetlejuice. Here she says the sidebar conferences will not be available on FTR until after the trial has concluded. And here she's conflicting herself and says sidebar conferences will not be available on FTR, like ever, or only after the trial is concluded. I have questions. 4, spectators and media are prohibited from attempting to provide specific identifying information of jurors or potential jurors to the public, including physical descriptions of the jurors. Okay, so we can't know how many men, how many women, the race of the jury, the racial makeup, the ethnic makeup of the jury, who's blonde and who's brunette, or who wears glasses or a bow tie, or, I mean, how far is that going to go? Physical description, specific identifying information. We can't know their occupations. I mean, yeah, we're just let's just ride blind. Gull, thanks for the tips. I'm taking some of your so ordered XOXO Kim Jong Kanone. That was dated today. Basic demographics should be allowed. I agree. Physical descriptions of the jurors. Okay, so I guess you can't describe them as being African American, but you can. I don't know. I don't know what the hell this means. I don't know. I only have over 30 years of experience as a litigator, and I don't know what the hell this means. Do I think that the jury should be protected? Sure. Of course I do. I don't think anybody should dox their name and address. But how far are we going? They already extended the buffer zone. It's more than 200 feet now, and it includes like a whole other extra area. Yeah, Brenda. Thank you, Brenda. Exactly. Remember AJ's words. We ain't got no quit. We ain't got no quit. Thank you, Brenda, for shining a light as the voice of reason. Appreciate you so much. Thank you, Anita, for your Venmo. Says, thanks for sharing your legal and common sense knowledge. I worked in healthcare physical therapy for 35 years. The investigation from a medical perspective is overwhelming in itself. Free Kearney, justice for John O'Keefe. Thank you, Anita, so very much. I appreciate you. All right, so let's take a vote. I'm not really going to do a really formal poll, but let me just see. Can anybody point to anything that they really, really, really want to talk about from last week that we have not already talked about today? And here are your choices. Actually, I take that back. Hold on, because I want to go over docket number 579, because this is a change from the last trial. So, shockingly, she gave one to the defense. And so docket, when this was just a little scribble scrabble decision on the bottom of the motion, number 579. And that motion, let's pull it up here, was to exclude the manner of death. It was the Commonwealth's motion in limine to preclude reference to and redact the manner of death on the victim's death certificate. So remember, Irene Scortibello was not able to determine that this was a homicide. The manner of death on John O'Keefe's death certificate has been and remains undetermined by the medical examiner. That's why Proctor called her a whack job. And that's why DeChico said, rookie move, you should have had me and Jeff do it. Kikowski, you should have had us talk to her to get her to change it. And here, I guess this was March 27th, so Thursday, the judge wrote a little note on the bottom of this motion, denied. The medical examiner will be testifying and can be examined on this issue. That is a win for the defense. During the last trial, my understanding was, from what I remember, it's been a long time, but they were not allowed to question the medical examiner about it. It was to be redacted from the death certificate, and she was not allowed to be questioned on it, right? correct me if I'm wrong, but my understanding is, if my memory serves, this is a change from the last trial where they were not allowed to bring that up. Right, exactly. Green-eyed Southern girl, exactly. And it is amazing how low our expectations are at this point, because Green-eyed Southern girl points out, wow, a win that shouldn't even be an issue. Right. Right. Oh, thanks, Gina. Do we have the same birthday? Oh, happy birthday to us from a month ago. Love your shows. Thank you. Thank you so much. I appreciate you. Patty Minko says 9 law clerk from BU are added to the defense per Ted Daniel. Oh, is he saying that? So they are 9. So 9 interns is what you're saying from Boston University are added to the defense team. They already had a bunch of interns, but perhaps many of them are graduating because no, it's only March, so I'm not really sure, but that's good. Let me just pull up that. Thank you very much, Patty, for laying some knowledge on us, being on top of it. Ted Daniel, who is, as you know, a reporter in the Boston area, has tweeted that there are 9 law students clerking for the Karen Reed defense. Oh, 9 law students. Does he say that they're all from BU? He's with Boston 25, for those of you who know. And then he links to an article that says 9 law students from Boston area schools are volunteering for Karen Reed's defense team, including 5 from Boston College, 3 from Harvard, and 1 from Northeastern. The students will serve as law clerks, assisting with case law research, document preparation, and courtroom analysis. Wow. I mean, first of all, what an amazing trial to be able to work on. This is going to be historic on every level. And also, they need the help. They need the help. And they'll have this on their resume forever, that they helped the Karen Reed defense team as law clerks. Reed told 25 Investigates reporter Ted Daniel that her team interviewed more than 50 candidates in the fall after her mistrial. Some of the clerks have been seated with her family during pretrial hearings. When did Karen talk to Ted Daniel? They are working pro bono for my defense, Reed said in a statement. 8 of the clerks are in their 3rd and final year of law school and are expected to take the bar exam after graduation. The clerks include, and then they name them. I'm not going to name them. And that was posted, that article on the Boston 25 News website was posted at 5:16 p.m. Look at us right on top of it. It's only 5:28. So thank you, Patty, for telling us that. Although they are from different schools, not all from BU, or actually BC, Harvard, and Northeastern. Puppet, thank you for your super chat. In my opinion, Karen's team should keep count of all the objections and ask for a mistrial each time. They cannot go to the sidebar for every objection. Well, I don't know. That might piss off the jury. So you kind of got to be careful with stuff like that. Thank you for your thoughts. Greg, thanks for the 10. She intentionally waited until the day before to drop the denieds on the defense. I think so too. Remember, Kearney goal, we start April 1st, hell or high water. The Cape is calling her. Thanks, Greg. You're not alone in your thoughts. Live, laugh, toaster bath, who always gets me on a tongue twister with that name. I remember when I was a kid from my mom's album of Sticky Fingers had jeans you could unzip. I thought it was so naughty. Yes. Yes. Do you remember that? Yes, I remember that too. Tyranny is live and well in Canton, Massachusetts, as Lying Witch in Black Robe. So true, right? Justin wrote, Bev, your bias is showing, says, say it once, I'll say it again. What Gull did in the darkness, Bev is doing it in full light. In my opinion, it's like she doesn't care who sees. Tuning in from Ireland. Thank you. See, the world sees it. The world 100% sees it. Mm-hmm. Hang on one sec. Okay. Nina, Another attorney said he would ask for a mistrial after the jury is selected because they couldn't voir dire the jury and therefore it can't be a fair trial. I don't know who said that, but I will say that if you ask 5 attorneys for 5 opinions, you will get 5 completely different opinions. So I don't know who said that. So I mean, you know, I don't know exactly what her rules are for the jury selection. Nobody seems to know. Doesn't seem like they're going to have a whole hell of a lot of participation in it. But I love you, Nina, and thank you for always being such a participatory contributor to this channel. Carrie became a member. Welcome. Sarah says, are you suggesting coconuts migrate? Who said that? Michael Proctor said that? Hope that helps bring a laugh. I'm not sure what you're referring to. Are you suggesting? I don't know. Should I get that reference? Thank you, Sarah. Be creative. I love you. Reed's bite is bigger than Chloe's says. Can you explain if the Commonwealth doesn't call someone, but the defense does, how that affects how the defense can examine the witness? Yes, they have to. If they call them on their case in chief, they have to direct examine them by just asking them questions that are non-leading questions. It's a different style of examination, but that's what you have to do if you call the witness as you're in your case in chief. You can't use leading questions. That's the main difference. Also, how are rebuttal witnesses different? Rebuttal witnesses can be called to rebut testimony from your opponent's case in chief, but that is the limited purpose of a rebuttal witness. I hope that answers your question. Thank you for the 10. Jackson's Do It from Norway. Thank you. Charge her with murder, but don't mention the cause of death. Right. Correct. And it's important also to note that homicide does not mean murder. Homicide means death at the hands of another, right? Or I'm telling you, maybe you don't know. So undetermined means she couldn't even determine that John O'Keefe's death was caused by another person, whether it was accidental or intentional or in any way. She couldn't even determine that much. So yeah, it's wild. The hearing on Friday with Cosgrove and Brennan. Oh yeah, should we look at that? Let's look at that. Okay. Thanks, nightclubs. Good Norfolk County citizen says, do you think Bev is asking for thoughts from her peers? I don't think she is. I don't think she cares. It's like the highway to hell. It's like her way or the highway, and it's like we're on the highway to hell. That's what I think. Thank you, good Norfolk County citizen. Monty Python. Oh, that's what it is, Monty Python. Thank you, Sarah. Be creative. For clearing that up in another super chat. And remember, David Yannetti, wait for us. Was it David Yannetti who said that? Alan Jackson. I don't remember, Patty, but it was one of them. She did not rule on Garrett Wing yet. They have just renewed their motion to preclude his testimony today. And we can't get our digits on that because it wasn't scanned into the system. But they did. The last thing filed today, it's number 658, Commonwealth's renewed motion in limine to exclude expert testimony of Garrett Wing. Because remember, the defense, I think the ARCA decision is out. Let me check my inbox. Let me refresh the browser. But again, just because it's on the docket does not mean that it was scanned into the system. But let's see. You may be right. I may be crazy. But this website is not very user-friendly because you have to scroll. I don't see anything about ARCA being out. There's the Commonwealth's motion to impound exhibit in support of Commonwealth's motion to compel reciprocal discovery of ARCA witnesses. So they made a motion to impound an exhibit in the motion, but there's no decision on the motion unless somebody else has it, but it's not in the docket. So hopefully that clears up that misunderstanding. All right, let me see if I can find the hearing from, that was Friday, right? I can't even believe that was only Friday. The surprise hearing called by Judge Sisitsky in which he spanked Brennan. 1 minute. Talk amongst yourselves while I find it. Because yes, we did not go over that together. And that is part of the Karen Reed case, not the Aidan Kearney case, which I still have so many questions about. Let's see. All right. I think this is the one, right? This is from March 28th. Yeah, so that was Friday, right? Okay. 1 second while I move this to the other screen. Everybody was on Zoom for this except for Brennan and Cosgrove. This is wild. Again, why was Judge Kearney not hearing this motion? Why has nobody asked why Judge Kearney was not hearing this motion? This was in the Karen Reed case. This was not in the Aidan Kearney case. Why was there a special judge assigned to this? His name is Sisitsky, Adam Sisitsky. Why didn't Judge Kearney hear this? People have pointed out because Cosgrove maybe had something to do with Judge Kearney's swearing in ceremony when she was sworn in as a judge, that she might have some sort of relationship with Cosgrove. And that's why she couldn't hear this Rule 17 motion, because she's heard every other Rule 17 motion in this case. Nobody's talking about why. Has anybody talked about why? Has anybody questioned this? I have so many questions. Why is nobody answering my questions? Why was this assigned to Sisitsky instead of Kearney? I have questions. I mean, from the get-go, I think it was a shell game in the beginning, and I think the judge felt like he was duped and he's mad about it. So let's listen. This was Friday's hearing.
Judge, this is 22117 and 23313, the Commonwealth versus Karen Reed, and separately the Commonwealth versus Aidan Kearney. Can I have the parties identify themselves?
Mr. Clerk, hold on just a moment, please. Sure.
Yeah, Mr. Clerk, hold on just a moment, please, because I don't think this has anything to do with Aidan Kearney's case, but let's just see what he says.
I need to plug in because I believe we have parties on Zoom.
Okay, I'm sorry.
It's also my understanding that we're only here on case 0117.
That was also my understanding.
Oh, well, why Clerk Jim? Why Clerk Jim? Did you then say also Aidan Kearney's case number? Did you guys think you were going to hoodwink this judge again? Because guess what? Judge Sisitsky is too smart for your shenanigans, Jim. Too smart for your shenanigans, Jim. Because he knows now, because now he's pissed. Because you tried to pull the wool over his eyes during the first hearing, which I think was on Tuesday, right? Oh my God, this week was it on Tuesday, the first hearing, or Wednesday? I don't remember. But it was right after that they said they were calling an emergency hearing, and it wasn't held the next day. It was held Friday. They had to get all their ducks in a row. Yeah, Clerk Jim, eat the crow.
Okay.
Thank you.
And do you have the Zoom identification link for me, please?
I do. It's right here.
Thank you.
There's no passcode.
Thank you.
And again, since Jim, Clerk Jim, is Judge Kearney's clerk, why is he now all of a sudden the clerk for Sisitsky? I have so many questions about this. We have had a lot of Rule 17 motions in this case. Rule 17 motions are motions to obtain discovery from a third party. Why is this judge here? It's not, there's something going on. And where's Brennan? Cosgrove is the special prosecutor that was hired to persecute Aidan Kearney, aka Turtle Boy. And here's Brennan moseying on in after the case has already been called. Josh, you may be right. Says the fact that another judge is hearing motions in Reed's case is showing Bev knows she has conflicts in this case. I just want to know why nobody's filed anything, why nobody's asked in open court. It just seems to be like a well-kept secret. I don't know, but I agree with you, Josh. But nobody's
Okay,
talking.
Mr. Clerk, you may
Judge,
call the
thank
case
you.
and identify the parties.
22117, the Commonwealth versus Karen Reed. Can I have counsel identify themselves, starting with the Commonwealth?
Oh, so funny how Clerk Jim all of a sudden got the case number right. And they had to call it again because Brennan wasn't even there. Oh, and then look at that. A signal jammer came in and the signal was jammed up. This is
Your
Channel
Honor,
10.
I'm Robert Cosgrove, special prosecutor on the Aidan Kearney cases, and I suppose for purposes of this motion, I'm the respondent to the Rule 17 motion.
Good morning, Attorney Cosgrove.
Okay, and if you haven't been following the Aidan Kearney case, aka Turtle Boy case, with us, because we do that on a separate stream and a separate playlist, this is Robert Cosgrove. He is the one who has dubbed Colin Albert, and has called him Colin Albert in open court more times than I can even count. He also has not learned how to pronounce Kearney. It's Aidan Kearney. Thank you. Thank you.
Morning.
He's also a retired judge. Cosgrove.
Hello, Your Honor. Timothy Bradle for Aidan Kearney. I see him on the Zoom for the record.
Good morning, Attorney Bradle. Good morning, Mr. Kearney.
And Mark Federer for Mr. Kearney. Good morning, Your Honor.
Good morning, Attorney Federer.
And good morning, Judge Attorney David Yannetti for Karen Reed, who is also present on the Zoom.
Good morning, Attorney Yannetti. Good morning, Ms. Reed.
Good morning, Your Honor. Elizabeth Little, also on behalf of Ms. Reed.
Good morning, Attorney Little. Anyone else here that we need to recognize before we proceed? Doesn't seem so. Okay. Folks, we are here on two related matters this morning. As an initial matter, we are here because there seems to be some confusion concerning my order of March 20th on docket 615 on the Commonwealth's Rule 17 motion. Also, we're here because there has been a motion for protective order, docket 636, filed by intervener Kearney, and so we will hear that as well. So with regard to my order, let me start by saying this. Going back to Attorney Brennan's affidavit filed in this case on March 5th, 2025, in support of the Commonwealth's motion for records, Attorney Brennan, you specifically stated that, quote, it's been represented to the court by defense counsel Bradle on behalf of Mr. Kearney that there's an implicit long-term mutual assistance and mutual defense agreement between counsel for Mr. Kearney and counsels for this defendant, Reed. On the basis of that sworn statement, I specifically inquired of you, Mr. Brennan, at the hearing on this matter last week, do any of the three categories of documents and data that the Commonwealth seeks by the Rule 17 motion include communications with Mr. Kearney and counsel for the defendant in this case? You replied, no, these would be privileged. So based on these representations and the court's belief that there were no privileged materials implicated by the Commonwealth's motion, I ordered that all communications between Mr. Kearney and Ms. Reed during the time frame in question with regard to these three articulated categories be produced. However, subsequently, the special prosecutor in Mr. Kearney's case, in possession of the documents in question on March 26, informed the court that, one, there are, in fact, a substantial number of communications within the documents and data requested that are indeed communications between Mr. Kearney and Ms. Reed's counsel.
Right.
And moreover, the special assistant district attorney in that case took the position, contrary to the one asserted by Attorney Brennan in this case, claiming that those communications are not, in fact, privileged. So my order did not specifically exclude from production communications between Mr. Kearney and Ms. Reed's counsel because the court was told there were no such communications, and in any event, the Commonwealth acknowledged that they were privileged. So my first question is to you, Attorney Brennan. Respectfully, did I misunderstand you, or perhaps vice versa? In other words, I understood that you weren't requesting the production of any privileged communications, to wit, communications between Mr. Kearney and Ms. Reed's counsel. And as such, if that is the case, and we did understand each other, I can simply clarify my order for Special ADA Cosgrove that those claimed to be privileged communications will be excluded from the Rule 17 production, and we can move on. If that's not the case, I'd like to hear why.
Yeah, and he's laughing about it because he's so mad. His head's going to pop off. That's how mad he is, number one. And also, it's like, did I misunderstand you or vice versa? Or read between the lines. Did you lie to me? Did you really have the audacity to get up and lie to me in front of a worldwide audience and open court and everyone? And that is what Brennan said. You can go back and watch the first hearing if you want, but I remember him saying that. And he said, no, that's not what I'm looking for. And he said they would be privileged, any communications between Kearney and Karen's counsel. And I'm thinking to myself, they wouldn't be privileged. Her attorneys don't represent him, but that's what he said. Now he's going to try and weasel his way out of it.
Yes, you may.
think there are two separate issues regarding privilege. One is whether Mr. Kearney's attorneys, Mr. Betterow and Mr. Brado, have privileged communications, and separately, Ms. Reed's attorneys' communications with Mr. Kearney. When Your Honor asked the question, I believe we were referring to Mr. Kearney's attorney.
No.
And so what I understood from the motion filings is that there were no privileged communications between Mr. Kearney and his attorney in those phones. And so there would be nothing privileged to protect.
Okay, I specifically asked, does this
Again.
include communications between Mr. Kearney and counsel for the defendant, Reed?
I don't doubt that you asked that if that is what happened, but that wasn't my answer to the question, because perhaps I was focused more on Mr. Kearney.
So
Okay. Perhaps you're a liar. Perhaps you're an absolute effing liar. Because when the Saints came marching in, because you tried to make it a secret ex parte hearing by not notifying defense counsel in Karen Reed's case that you were actually having this hearing. And the only reason they found out that this hearing was going on without them was because they were sitting in the basement of the courthouse watching it on YouTube. Maybe that's what you were more focused on, that the Saints came marching in to steal your thunder and make you look like the absolute lying slime ball that you are. Maybe it's too bad that you lied, but you did lie. And at least this judge is going to call him out on it. Unless he's vocabulary is like, I could watch this all day long, a million times.
you confirmed today that we misunderstood each other.
Or I misunderstood. I'll take responsibility.
Or you
for it.
lied.
But I was trying to be protective of the attorney-client privilege between Mr. Kearney and his attorneys, Mr. Brado and Mr. Betterow.
Bullshit.
Well, we all agree,
Bullshit,
counsel,
because-
that those in fact.
How about bullshit? Because if you did care one iota about any sort of attorney-client privilege, you wouldn't have made a motion to obtain the messages between Karen Reed and David Yannetti by saying that she opened the door and waived her privilege by some statements she made on a documentary. So we don't believe one word you say when you're saying that you were trying to be protective of somebody's attorney-client privilege. Guess what? That rings hollow. Hollow. Let's hear it again.
Kearney.
So you confirmed today that we misunderstood each other.
Or I misunderstood. I'll take responsibility for it. But I was trying to be protective of the attorney-client privilege between Mr. Kearney.
Lawyers
Oops.
and the
Did you hear the judge laugh? Did you hear the judge laugh? Hold on.
Kearney and
Hold on. Sorry, we keep replaying. The judge should have found him in contempt. Yep. This guy is getting away with way too much. And he's too experienced, Brennan, to be getting away with this. He's not a newbie. He may be a newbie prosecutor, but come on. The laugh says it all. Yeah, let's hear it again.
In those phones. And so there would be nothing privileged to protect.
okay, I specifically asked, does this include communications between Mr. Kearney and counsel for the defendant, Reed?
I don't doubt that you asked that if that is what happened, but that wasn't my answer to the question, because perhaps I was focused more on Mr. Kearney.
So you confirmed today that we misunderstood each other.
Or I misunderstood. I'll take responsibility for it. But I was trying to be protective
The
of
laugh.
the attorney-client privilege between Mr. Kearney and his attorneys, Mr. Brado and Mr. Betterow.
Okay,
I did
well, we
not-
all agree, counsel, that those in fact would be privileged communications
course.
without question.
Of course.
So let's turn to, if you would, the second issue, which is one that you raised in your affidavit. You specifically raised that question in your affidavit, docket 547.
Undoubtedly. I do not believe there is any attorney-client privilege between Ms. Reed's lawyers and Mr. Kearney, because those communications are not covered by attorney-client privilege, because none of Ms. Reed's lawyers are attorneys for Mr. Kearney.
So in what world would you be entitled to those communications to prove Karen Reed's consciousness of guilt? Because that's what you're saying you want to use them for, right? And remember, in his motion, he had the audacity to even say, well, I'm only making the motion to, to go through the proper channels because, we know that I could just go into that file and pull what I needed. But I'm doing the right thing here. Pat me on the back by making the motion, because I could really just go into the Kearney file and take what I needed, because it's a Commonwealth file, and then I could just use it against Karen Reed, and I'm just going to make the motion just because I'm trying to be a good boy. Gross.
I pointed out that in an earlier hearing, and I have the transcript of it, it was December 17, 2024, when there was litigation in Mr. Kearney's case, docket 0313, that there was a position taken by Attorney Bradel. And he began by telling Judge Krupp, well, there's a joint defense issue, Your Honor. And Judge Krupp asked, so it would predate any jeopardy to Mr. Kearney. And then
I'm sorry, did you forget that Bradel was on the call? Because he's going to hammer your head into a wall in about a second. So get prepared.
Mr. Bradel responded, well, it's a little more complicated because we know he was under investigation along with Ms. Reed without any resultant charges. So we would contend that does not fall under the umbrella. After more questions by the court, Mr. Bradel answered, we don't have an agreement, but there's been an ongoing long-term implicit mutual assistance and mutual defense that I myself have been part of for a long time, and Attorney Bedrow has as well. And Judge Krupp said, I really have no idea what that is.
And he just wanted to read all of that into the record, right? He just wanted to read all of that into the record. It's not why we're here. It's not why we're here. You lied to the court the other day, and he's calling you out on it. And so, nice try, but this judge is too smart for this.
And so inevitably, there was no establishment of an attorney-client relationship between the two. Inevitably, and after that, Attorney Bedrow attempted to file an appearance on behalf of Ms. Reed.
Oh,
And in that, there was a supplemental motion, and it's docket 549 and on 0117.
oh, now you want to disparage Bedrow a little bit more? Oh boy, this is gonna. I don't know that I watched this on Friday. I was in Vegas. Wow, just wow. The world is watching. That thumbnail I did last week of him next to the weasel. Chef's kiss.
7.
And docket 549 contains Attorney Yannetti's sworn statement that there was no joint defense privilege between Ms. Reed and Mr. Kearney.
Yeah.
And so I think I had the assumption there was no attorney-client privilege. If I misspoke, it confused the court. My apologies, but inevitably, there is no attorney-client privilege that I understand exists. And so
The judge just called him out. He went through the trouble of getting the transcript from this prior hearing in Aidan's case to read all of this stuff into the record about a joint defense. And this judge is too smart for that. He's like, yeah, but there's an affidavit from David United saying absolutely that's not true.
I do not know what is in these phones. I have not asked. I don't want to know.
Bullshit.
Pursuant to a court order.
Bullshit. I bet you $100 that he absolutely knows what's in there. I bet you money. I would bet you money that he went into that file and read whatever he wanted because he already said he was allowed to. Now he just wants to make a motion to try and get it. Right?
But based on the affidavit of the search warrant and based on the pleadings in this case, and there's two very important pleadings, I may have mentioned them to the court on the
We did
last
some
day.
homework.
But those pleadings, which were filed publicly by the Commonwealth, and it's docket number 53 relative to Mr. Kearney's case 0043. In that pleading, it is set out by the Commonwealth's pleading that there is, in fact, information demonstrating that the Reed team provided Mr. Kearney with information, documents, videos. It's suggested that at times they would suggest angles for him to use it or to refrain from using it. And it provides
For stories, giving a reporter information is not, there's nothing wrong, there's nothing improper about that. Have you, is this your first trial? It doesn't show consciousness of guilt. Everyone smash the like button or I'll have to turn off the air conditioning.
a number of examples, including an example on 8823, when they're asking for information, Mr. Kearney, so one of the attorneys.
Attorney Brennan, I'm going to ask you to pause right
Of course.
there because I think we've reached a point where I have a threshold issue that may require either a Bishop Franklin protocol or some inquiry into the nature of the privilege that may or may not be asserted.
Mr. Brennan, I'm going to ask you to STFU, talk to the hand, because I don't want to hear what you have to say anymore because you're a lying weasel. And I know Judge Kearney may allow you to grandstand and say everything to the worldwide audience that, you want, but this judge not having any of it. None.
By Attorney Bradel. And so I think it's appropriate at this time, Attorney Bradel, that I turn to you, not with regard to the protective order, but with regard to the issue of whether your client claims a joint defense agreement and related privilege to communications between himself and attorneys for Ms. Reed, such that I need to limit the scope of my order of March 20th.
Judge, thank you. We do not assert such a privilege. I said in a much different context a long time ago that we had been sharing information and talking to each other and helping each other. And I said that there was an issue. I didn't say there was a privilege.
Okay.
So we are not asserting that. There is no formal agreement. There's no formal privilege. I said it was an issue to be looked at the time. That's all I said, Your Honor. And in terms of this, Your Honor's order, I don't even know why we're talking about this, Your Honor. The ostensible purpose of the Commonwealth's request was to attempt to show consciousness of guilt on the part of Ms. Reed. So why would communications to other parties besides Ms. Reed have any relevance? And in fact, in your order,
Right.
you just say that the only communications that are on the table here, so to speak, are communications between Mr. Kearney and Ms. Reed.
I'll stop you right
Nothing
there,
about
Attorney Bradel, because you
lawyers or
raised
third parties.
an excellent point, and that point being is that point from the court's perspective is in an age of group texts and other means of communications with multiple recipients at the same time, we certainly have the likelihood of communications between your client and Ms. Reed that may also include members of her defense team. So it is my belief that is what might be at issue, but I will probe further of ADA Cosgrove on that point.
I mean, if you ask me, Your Honor, the pleading, the impounded pleading filed by Mr. Cosgrove is completely immaterial. The whole reason for this is consciousness of guilt. So there are we are privy to these extractions. There's absolutely nothing in them that is covered by Your Honor's order. There's no communications between Mr. Kearney and Ms. Reed regarding witness intimidation. There are none. So there should be exactly zero documents or texts
Exactly zero.
that should be responsive here. Absolutely zero. And I don't have the thumb drive that Mr. Cosgrove gave to the court ex parte. So I can only imagine what's in that. And we are anticipating a request that you will look at that, to ask you to look at that in camera and see if that complies with your order. It doesn't. It cannot comply with your order.
Right.
Your order says
There should be zero.
Kearney and Reed, not third parties that may or may not have spoken to Reed. And these are things that are privileged among that team. So this is a can of worms that the court did not open by any stretch. And I think that, Mr. Cosgrove's role here is completely ministerial, Your Honor. And the fact that he's trying to jump outside of your order is incredibly inappropriate, in particular because these two prosecutors are in different positions due to a conflict of interest, an expressed conflict of interest that has been identified and supposedly acted on by District Attorney Michael Morrissey. So their communications need to be limited because there is a conflict. Your Honor limited those communications very appropriately to potential evidence that those two defendants could have communicated in terms of some criminal acts.
Right.
And we're telling you there's nothing there. We don't expect you to rely on our interpretation, but there is nothing there relative to your order.
Thank
So
you,
the fact that
Attorney Bradel. I'm gonna ask you to pause for a moment, and I'm gonna hear from Special Assistant District Attorney Cosgrove, specifically with regard to this issue.
I really liked Tim
In your
Bradle a lot.
communication to the court, you suggested that in your judgment, the production would sweep in a substantial number of communications between Mr. Kearney and Ms. Reed's attorneys. How would those be swept in when the order specifically calls for communications between Mr. Kearney and Ms. Reed?
I think the actions of Ms. Reed's attorneys on her behalf are the actions of Ms. Reed. And if one reads the,
Wow, you're even a bigger dumbass than Brennan. Really? So the actions of Karen Reed's attorneys are imputed to Karen Reed, retired Judge Cosgrove. Thank God in heaven. I feel bad for any defendant that was ever, I don't know if he was even a criminal judge. I have no idea. Did you hear what he just said? That he imputes Karen Reed's attorney's actions to Karen Reed. Okay, hold on a second. Is this your favorite part, Diane Gallagher? Hold on.
For communications between Mr. Kearney and Ms. Reed.
I think the actions of Ms. Reed's attorneys on her behalf are the actions of Ms. Reed. And if
Wow.
one reads the sweep of the communications between Mr. Yannetti and Mr. Kearney, and between
Right.
Mr. Jackson and Mr. Kearney, and Ms. Reed and Mr. Kearney, one sees a pattern of feeding information to Mr. Kearney.
Oh, yeah. But remember the grand jury that you convened to try and indict them on conspiracy to intimidate witness charges all the way back in March of 2024? And, you know, famously, Judge Saul Wackler, who was chief judge of the highest court in New York State, said a prosecutor can get a grand jury to indict a ham sandwich. Well, the grand jury did not indict the ham sandwich. That was Karen Reed and Aidan Kearney. So none of this is flying with anybody. They're trying so hard to get Karen Reed convicted of something, anything, fishing expedition, like, get her to violate her bail so you can throw her in the Norfolk County jail. Like, they will stop at nothing. Hi, Microdots. Hey, Richie. What up? Microdots is in the house. They will stop at nothing. This guy's insane.
I think that they act together in that respect, Your Honor.
They act together. Okay.
Thank you, Attorney Cosgrove.
How did he not laugh at that?
Notwithstanding that position, the court's position is that the order spoke very specifically and very clearly to limit the Rule 17 motion to the production of only communications between Defendant Reed and Kearney and Defendant Kearney concerning those three areas of inquiry. So I am specifically requesting and ordering the Commonwealth in that case to review the documents called as a result of the Rule 17 motion in my subsequent order, such that the production will only include communications between Kearney and Reed.
Yeah, what's so hard about that? What part of my order did you not understand? What part of my order did you not understand, former retired Judge Cosgrove, when I said turn over text messages between Karen Reed and Aidan Kearney, and then you file a whole effing thumb drive in there? And didn't he also, because I don't have these papers, I don't have the papers, but didn't Cosgrove file something where he actually like typed out some of the messages between Yannetti and Aidan Kearney? I don't have those papers because, you know, I went off the grid, Grateful Dead, Vegas, the whole thing with Andrea Burkhart this weekend. And so I don't have those papers yet, but I'm going to get them and we're going to look at them, because how dare he put that out there? They are trying so hard with the nothing that they have as evidence to get Karen Reed convicted by putting all of this out there in the public domain. They're in the footnotes. Yeah, but was it in Aidan's? Was it in Aidan's? Was that filed, Blackbird, in Aidan's case? I think so, right? In the footnotes. Deanna thinks Jim is shady. The audacity.
Well, I will, of course, comply with Your Honor's
Oh,
order.
thank you so much.
Folks, I think we've covered that point, and I don't think I need to hear any further on this. The order is clear on its face, and I expect the parties to comply with it. I'd like to turn now to the issue of the motion for protective order from Mr. Brado. So I'll hear you on this, appreciating that I have had the opportunity to review the attachments and certainly the basis for this, but I'm not, I'll preview where I end up, Attorney Brado. I'm not quite clear
Sure.
on the scope of your request as contained in your draft order. As an initial matter, I'm only issuing an order in the Reed case. I am not, this is not a hearing on the Kearney case.
Right.
I appreciate that you have a congruent request to the court in the Kearney case.
'Cause we like
and that it
Judge
may
Doolin
make
for that.
sense that whatever the court does in that case should follow what the court does in this case. That would seem to make sense. But I'm only hearing the motion as it regards to this case. Your request, I'll note, asks,
Before we get there, orphan methodology says, how can they do this with no defendants there? They're on Zoom. They're on Zoom.
that the court order all prosecutors and police in the above captioned case to maintain the confidentiality of the cell phone data and any other investigative information and or discovery in each case. So
Right, because here's another thing. Here's another little side note on the Aidan Kearney case. My recollection is being not so exhausted anymore. They want to have a hearing with Jennifer Coffendoffer to come in to testify, with Kate Peter to come in to testify, and Kevin Lenahan of the Yellow Cottage Cheese to come in and testify about where they are getting these leaks from the Norfolk County DA's office. Where are these leaks coming from? That's why he moved for a protective order. If anybody has the papers, please email them to me. My email is in the show notes below, so that we can do a separate stream on that, because that is wild. Because it seems like Coffendoffer, Yellow Cottage Cheese, and not so confidential informant Kate Peter always seem to have breaking news that is not in any public documents. And they made a motion about it. We need to go over it because it's wild. And I am so here for that. I am so here for it. But that's in Aidan's case, which is why I want to make it a separate stream. But it's just a little taste of what's going on. And also the Bettero letter. It's also in Aidan's case. So we'll do that separately.
I'm not prepared to discuss the entirety of investigative information and all discovery in this case. I am tasked with only addressing Mr. Kearney's specific cell phone data that is the subject of my order of March 20th. But you've specifically requested that the court order that police and prosecutors are ordered to refrain from sharing such information with particular parties identified in Mr. Kearney's affidavit and any other parties not part of the retained prosecution teams of Ms. Reed or Mr. Kearney. Aren't they already under a duty not to share such information with anyone outside the bounds of what you requested?
Yeah, but
They are, Your Honor. Judge Kearney specifically found a substantial risk existed that any further communications about the evidence or the witnesses would jeopardize a fair trial. And she made that specific finding, and she imposed, I believe it's a 4-part gag order on the Reed attorneys. Nonetheless, as shown in my exhibits, Judge, these outside people are receiving information that in no way would the prosecution team ever share outside of anything ethically share anyway, any such information.
Did you see how he qualified that? Ethically share, I should say. Exactly what he's talking about. Coffendoffer, and they're named in the papers, right? They're named in the papers. Coffendoffer, Kevin Lenahan, and Kate Peter.
Information. And there's 3 examples of people who are, out there saying we've gotten this, we've gotten that.
Yep.
And we strongly believe that they are doing so. Just to avoid the slight awkwardness, Judge, of me arguing something that benefits Ms. Reed, I would invite just for the record,
Yeah.
the Reed counsel
Bring
to join me in this motion, Judge, because of the leaks that are going on, just as a threshold matter, if I may do so, Your Honor.
Are you merely
Let's just point out Polly Pocket's Power Trip has one of the greatest names I've ever seen. All signs point to Clerk Jim and Laura McLaughlin. Nina says, Bettero letter, October 2024. Yeah, there's a lot of Bettero letters. There was another one that dropped on Saturday night as well. So that's the one that I'm talking about. Oops. Wait, I think this is the suspender line. Hang on.
Leaks that are going on, just as a threshold matter, if I may do so, Your Honor.
are you merely asking me to add a belt to Judge Cannoni's suspenders?
I think so, Judge, because we need one, and we need one as to the specific information. These three people have repeatedly stated that they're privy to inside information, and with respect to Mr. Kearney's information, although we strongly contend there's nothing in there that is responsive to Your Honor's order, nothing. To the extent that there's anything that's shared between these two different prosecutors that are on separate islands due to a stated conflict of interest, we want to specifically ensure that as to the discovery that Your Honor's focused on here, that these orders are in place, that there's a specific order. It's sort of another step from Judge Cannoni. She said that, well, the general rules of ethics aren't working here, so I'm making a specific finding. I'm giving you a gag order. Well, guess what? Judge Cannoni's order didn't work either, based on my exhibits A, B, C. And so we're asking for another step to just really put a fine point on it, that these three people must stay away, and a general order as well as part two is my part two. And to the extent that those people have any sort of further expressions of leaks in the media or on the internet, I think that ought to be grounds for a live hearing with sworn testimony.
A live hearing.
These leaks.
Understood. Okay.
So that's why I'm asking.
A live hearing about the leaks with sworn testimony from Jennifer Coffendover, Kate Peter, Kevin Lenahan of the Yellow Cottage Cheese. And yes, Carol, I will allow it. First, thank you, Shiraz, for hanging out with me for 16 months. So grateful for you, for bringing this to LawTube. My pleasure. It is my pleasure. And also, that was the quote. Do you want me to add a belt to Judge Cannoni's suspenders? Love it. Maybe staple them on too. Yeah, because apparently her court order means nothing to the leaks that are happening within the Norfolk County DA's office to these outside twidiots who have no business knowing any of this information. I didn't realize I was covering up Hank Brennan. And I think we need an evidentiary hearing, Judge. Oh, I can't wait for it. And I think that's in Aidan's case, though. So it's maybe that will be from Judge Doolin. So hang on, because I want to see Brennan's face. I was covering his face. So let me just rewind that back a second. But we really can't see his face because we only see his profile when Bradel's talking.
There's a specific order. It's sort of another step from Judge Cannoni. She said that, well, the general rules of ethics aren't working here, so I'm making a specific finding. I'm giving you a gag order. Well, guess what? Judge Cannoni's order didn't work either, based on my exhibits A, B, C. And so we're asking for another step to just really put a fine point on it, that these three people must stay away, and a general order as well as part two is my part two. And to the extent that those people have any sort of further expressions of leaks in the media or on the internet, I think that ought to be grounds for a live hearing with sworn testimony about these leaks.
Oh, well,
Understood. Okay.
So
we can't see Brennan's face.
Judge. Thank you.
Thank you, Attorney Bradel. Attorney Yannetti, do you have anything to add on this point?
We don't. I mean, I think that we generally take no position here. It is concerning to me that Special Assistant District Attorney Cosgrove revealed in a publicly filed motion communications with, or I should say between Mr. Kearney and counsel for the Reed team when the court's order was specific. My understanding is that he omitted some statements of caution and admonitions that we may have given to Mr. Kearney about.
Cosgrove cherry picked those footnotes that he published. Are you surprised?
The nature of demonstrations, etc. So it seems as though he cherry-picked statements in an effort to make us look bad when it was outside the court's order. It was unnecessary.
Attorney Yannetti, are you speaking to something that Attorney Cosgrove has purportedly done in this proceeding in the 117 matter?
No, I believe it's a motion that he filed in his prosecution.
Right.
Again, detailed, that material.
Detailing those text messages, right? So
Okay,
slimy.
folks, I will take that matter, the motion for protective order, under advisement, and will endeavor to respond to you as soon as practicable on my decision on that. In the interim, ADA Cosgrove, Special ADA Cosgrove, I'd ask you, how soon do you believe the Commonwealth can reproduce the records in question per my order that are called for by the Rule 17 motion?
Well, I would say we can probably extract from the thumb drive the conversations with Mr. Yannetti and Mr. Jackson.
Yeah, all of the
I
inappropriate
may
stuff
be
that you
able
weren't
to get
supposed to
it
turn
done
over.
today. I think Monday would probably be a realistic filing date.
Thank you. We'll expect something by close of business Monday, and if you encounter any
Hmm.
difficulty or challenges in doing that, just please let the court know, and we'll make whatever accommodations we need to make. Okay, folks.
Your Honor, is that thumb drive going to get returned to the Commonwealth?
Mm-hmm.
Yes, it will.
All right, thank you.
And it has
Before it
not
leaks.
been viewed, it has not been released, and it is being
Hmm.
held under
Not that
seal
you know
and
of, Judge.
impounded at the moment, and it will be returned to the Commonwealth promptly.
Not that you know of, Judge.
Thank you very much, Your Honor.
Attorney Brennan.
Your Honor, just for clarity of the record, I'll be brief. There has been no conversations between Special Prosecutor Cosgrove and I about contents of any of these items. In fact, even though I do not think I
We didn't talk about it. I just took a little sneaky peek into the file because, I'm allowed to. I'm allowed to do that. We didn't have any conversations about it, maybe. Maybe use Signal or WhatsApp or, private email burner servers, but burner phones. We didn't have any conversations, Your Honor. Trying to show that he's ethical. We can see right through you. As Alanis Morissette used to say, still says, see right through you. Walk right through you.
about contents of
Right.
Your Honor, just for clarity of the record, I'll be brief. There has been no conversations between Special Prosecutor Cosgrove and I about contents of any of these items. In fact,
Pro
even though I
sector.
do not think I had to, that's why I filed the Rule 17, so there is a clear public record that we're beyond reproach.
Even though I didn't think I had to. Do you see that he's still defending his position? Even though I didn't think that I had to file this motion because I could have just went into the file and took it. The fact that he's able to say this in open court preceded by, I'm very ethical and I would never have any conversations with Cosgrove. I can't believe he just said that. Hold on. My head's going to pop off. Hold on. I got to go back.
Between Special Prosecutor Cosgrove and I
Pro sector.
about contents of any of these items. In fact, even though I do not think I had to, that's why I filed the Rule 17, so there is a clear public record that we're beyond reproach. Secondly,
Even though I didn't have to, I filed the Rule 17. What? Is this the way they operate in Norfolk County? They just go into other defendants' files and pull whatever evidence they want and then use it against another defendant in another prosecution? What?
I referred to were pleadings that were filed in Mr. Kearney's case publicly before this issue even came up. So it is not divulging information to disseminate to the public. And finally, just so it's crystal clear,
Crystal.
I filed a motion for a gag order in
Oh,
Ms.
yes.
Reed's case because there was significant evidence of distributing protected materials. And that order was allowed at my request. There is no witness.
Oh, please do not dislocate your shoulder, patting yourself on the back. The leaks are coming from the prosecutor's office to the not so confidential informant, the maybe former FBI agent on Twitter, and the yellow cottage cheese guy. I don't care who filed for that. Congratulations, golf clap for you. It's a completely different issue.
or person, as far as I know, in the Reed case, that has disseminated any information improperly. I would not allow it or tolerate it if it happened.
Really?
I want that to be crystal clear based on the representations we just heard.
Crystal.
Understood.
From a
Thank
few
you,
good men,
Attorney
you're right.
Brennan. Thank you, Attorney
Your Honor,
Cosgrove. Thank you,
Can I speak to
counsel.
that, can I
No,
speak to that very
we are
briefly?
adjourning the hearing now. Thank you, counsel.
Yeah, David, you know, he tried to get something in. He's like, no, we're adjourning it. But you know,
Thank you, Your
and
Honor.
I'm not faulting Sisitsky for this because he just wanted to get the hell out of there. But you know, let Brennan make his record of how ethical he is. Can we please get the Silver Fox rotated in for 2.0, says Jay and Hull, free Karen Reed. Wow. And Michael points out a few good men. Clear? Crystal. Well done. Linda says, not going to lie, this is getting so hard to watch. I won't stop because I'm going to support Karen, but all of this just makes my heart hurt for her. Yes, you are not alone. KLM says this hearing followed by the Betero letter fits perfectly. Although I'm not going to have time to read that tonight. We're going to do it on a separate Turtle Boy stream when I get some more papers. Thank you so very much for your super chat. Josh says, well, Josh put this up first, which I put up earlier. The fact that another judge is hearing motions in the Reed's case shows Bev knows she has conflicts in the case. And then Josh says, right, they had a joint defense when the Commonwealth impaneled the grand jury against both of them for witness intimidation. But here's the rub, Josh. They didn't know about the grand jury. They didn't know about the grand jury, and they didn't know that the grand jury refused to indict by not returning a true bill because and that happened before the first trial. The Commonwealth never told Karen Reed's defense that this had happened, which is another problem in my opinion. So many problems here that we don't even have time to go through them all in the 3 hours and 21 minutes that we've been here. Grace Base, someone please teach Hank what inevitably means, or supposedly, how to pronounce supposedly. Polly Pockets Power Trip is here and says, can we please get a weasel emoji for this trial? It's necessary. I'm going to take that under advisement and I'm going to write it down. And we also need a swiper. Adora swiper. Keep swiping. Weasel. I will allow it. Suze, Cosgrove had never filed a motion in this case until prior to this hearing, and the footnote contained messages between Aidan and Unetti or Jackson. Yep, because he wanted that out there in the public, right? Of course he did. Never filed a motion. He's never responded to discovery. They're still waiting for discovery in that case since October that they are entitled to under the reciprocal discovery rules in the Aidan Kearney case. He still hasn't turned it over, but now all of a sudden he files a motion, right? Only because he wanted to get stuff out to the press. Guess his usual leaky sources were not available, or he wanted to be in public record. So when the leaky sources started talking about it, it was in the public record. That's my opinion. I'm sticking to it because, you know, they got to plug that leak. Plug that leak. Not a big enough finger to plug the dam, in my opinion. And Ms. Stone, 518, who is the guy in the blue shirt? Look who is sitting next to him. Brennan goes over to them afterwards. Oh, you mean in the gallery next to the ex-girlfriend of John O'Keefe from like 20 years ago? Who is that guy? Is that one of the guys from the documentary that was like a friend of, he's been in the documentaries. His name Brendan or Brandon or something. He was a friend of John O'Keefe's from childhood or something. You guys tell me. Put it in the chat. Who he goes over to at the end of that hearing. Can't remember his name, but thank you for your super chat. Why do all of Bev's rulings for the defense seem to laying base for no bias? Karen Reed, David Niedetti, Combs, for example, she knew there weren't any from the trial once, so she had no choice. I don't know, Kelly. I don't know. I'm not really sure I'm not picking up what you're laying down, but I'm sure it's an excellent point, and thank you for making that excellent point. I appreciate you. Nightclubs, you see Bettero's new letters. You see the defense motion to get the witnesses paid to testify. Defense wants witnesses that don't want to testify. Defense wants amount the Commonwealth paid their experts. That is common practice. Did I see the defense motion they want to pay witnesses to testify? I don't think I saw that. Hold on. Let me look through my list here. No, but you know what? Tomorrow we're going to have more time to talk about it. But they're entitled to how much the Commonwealth paid their experts. That's a very, very common thing. I don't know about the defendant wanting paying witnesses that don't want to testify. That I didn't see. So I'm not sure, but I'll take a look for it and hopefully speak about it a little bit more intelligently later. Thanks, Jackie, for your super sticker. Thank you, Shiraz, for being here for 16 months. So grateful to you for bringing this to law. Oh, you're so welcome. It's my pleasure. Do nothing I'd rather do than be with you guys every day. People say to me, would you want to join the defense team? No. Do you want to go sit in the trial every day? No. I love what I'm doing right here with you, screaming into the closet together about all of the injustice that's going on. Nina says Hank wanted a gag order while leaking stuff. Is wild, isn't it? May not have been him leaking it, though. May have been coming from the side prosecution of Aidan Kearney. Right? Be the belt that distributes the lashings. Thank you, lucid visionary girl, so much. Bias Bev's heavy size says the stark difference between the fairness of this judge versus size I'll allow it. Kearney is really telling. I really didn't want to believe that she was corrupt, but at this point, it's unavoidable. Listen, if you haven't been watching the Turk trial with me, it's also in this courthouse. It's another great judge. His name is Mark Halal. We love him too. There are good judges in Norfolk County. We are seeing them. Judge Doolin is another one. And the differences are stark between the Turk trial and the Karen Reed trial. And it just makes me think how ironic it is, how much differently this trial would have turned out the first time had it been assigned to another judge. And so, again, going back to your comment, Bias Bev's heavy size, was it intentional that it was assigned to Judge Kearney? I mean, the more and more that time that goes by, the more shenanigans we see, the more tomfoolery and ballyhoo that goes on in front of Judge Kearney, and the rulings by Judge Kearney are making it seem like it was intentionally assigned to her and intentionally ordered to be kept by her, because none of these other judges that we've seen would have stood for 1/10 of the shenanigans that have gone on, right? Looks like Hanky halfway to hammer haircut. Oh, that's right. We're calling Turk's haircut the hammer haircut by the prison or the jail barber. Thank you on top, because I know you've been with me all day. All day, Donna. Thank you for becoming a member. And Monge, does Bev not care because she's 5 years from retirement? That's one theory. Nina, imagine if they were successful on framing Lucky the snowplow driver, nobody would care and he would rot in prison free country. And I felt that way during the trial too. I'm like, why? Lucky would have been the fall guy. And he was such an honest witness that really tried to protect the Alberts. He really did. Like, it was like he liked them and he knew them from childhood. And that would have been a major, major tragedy, in my opinion. And does Lucky even realize that he would have been the fall guy for them had this pin it on the girl thing not really worked out, right? All right, you guys, let me just check in one more place to see if there are any more super chats. And I'm going to send you oh, hold on a second before we go. Before we go, thank you so much to a special friend who has sent me Judge Sisitsky's gag order, which has just been docketed in, I guess it's in the Karen Reed case because it says it's docket number 650. Thank you so much. This is just a friendly reminder to all of you who are on the cesspool of Twitter. Those of you who do choose to participate there, make sure that you go follow Olivia Lambo on Twitter and Lana Del Turtle on Twitter, because they both have ways of breaking this stuff down unlike anyone we've ever seen. Let's see Sisitsky's order. It's here. It's hot off the press. Docket number 650 in the Karen Reed case. This judge is not afraid. He's not afraid. Let's read it together. Shall we? We shall. After this, I'm going to teleport you over to Young Jerks so that you can hear from Betterow. But stay with me while we read this, okay? Docket 650. This is Commonwealth versus Karen Reed, again, by another judge, not Kearney. Order on intervener Aidan Kearney's motion for a protective order. Got to get me a red pen. Hang on. Trying not to sweat myself out. So many balls in the air at all times. That's what we do. That's how we do it. We pivot. It's like a cold read again. Order on intervener Aidan Kearney's motion for a protective order. Before the court is intervener Aidan Kearney's motion for a protective order regarding sharing of cell phone data after a hearing on March 28th, 2025, that was Friday, we just watched it, and a review of the submissions related thereto, the motion is allowed in part. Wow. Ruling in favor of the defense and/or Aidan Kearney. It's hard to believe, but we're reading it together. The intervener has raised significant concerns regarding confidentiality related to the Commonwealth's prosecution of Mr. Kearney in this other docket number, specifically his concerns over law enforcement's use and/or dissemination of data obtained by search warrant and extracted from Mr. Kearney's cell phones. The court deems interveners' concerns sufficient to warrant further court action. However, only as it pertains to data that is being produced per the court's March 20th of 2025 order in this case, meaning the Karen Reed case, and only as it relates to the above captioned case, which is the Karen Reed case. The court acknowledges that other investigative materials or discovery beyond that covered by this order are already the subject of the court's prior order, docket 555, concerning counsel's obligations. That is the gag order, Judge Kearney's ruling on the gag order in the Karen Reed case. And intervener Kearney has also moved for an identical protective order in the pending case in which he's a defendant, which is a different docket number. That motion is not currently before this court, right? So he's saying, I don't have standing or jurisdiction over that other case, only this one. And so that's why I'm ruling in the Karen Reed case the following. With regard to the data extracted from Mr. Kearney's phones and produced per the court's March 20, 2025 order, the court orders all agents of the Commonwealth, including but not limited to any member of law enforcement, of any law enforcement agency or agent or contractor thereof, shall maintain the confidentiality of the data and shall not share, publish, disseminate, or otherwise disclose the data or any information concerning the data to anyone other than counsel of record for the Commonwealth in this matter or counsel of record for the defendant. That means no Coffindoffer, no Kevin Lenahan, yellow cottage cheese, and no Kate Peter, mafia masshole, not so confidential informant. Number 2, this protective order shall take effect when entered and shall remain in effect unless terminated by an entry of a court order. Number 3, any person who violates this order shall be in contempt of court. And you heard Bradel saying he wants a hearing. He's probably going to get it in Aidan's case because Judge Doolin is also a very fair judge. So ordered this 31st day of March, that's today, 2025, XOXO, Adam L. Sisitsky, who you guys have named the Silver Fox judge. I will allow it. There you go. How many of them have already tweeted such things that are supposed to be under this protective order? I can't wait. Can't wait for it. Good judge. Fantastic. Blackbird says this case makes me want to rewatch Veep. So there it is. Trying to plug up the leak. Will it work? I don't know. Well, that was a fun 3.5 hours we spent together. Thank you to the moderators for keeping the chat classy today. It is never easy when we cover this case, but it is always, always worth it. Tomorrow starts jury selection. Thank you, Colleen, for your Venmo, who says, free Karen Reed, watching from Pittsburgh. I have no words for the total injustice being done against Karen through Judge Kearney. Her response to motions, perhaps she should be reminded the whole world is watching her. The whole world is watching you. Judge Kearney. Consider that. Oops. Consider that your reminder. Stephanie, thank you so much for your very, very generous Venmo, who says, just because I'm speechless and enraged beyond capacity, wow, this will be quite a ride. They are hoodwinking her full throttle. Yeah, and the world is watching, and you guys know it, and you guys can see it, because all of you have such amazing common sense, and you are smarter than the average bears, or ducks, I guess we should say. Tomorrow, we will stream live anything happening on the Karen Reed jury selection. It's not going to be long. It's probably just going to be the judge's opening remarks, counsel's opening remarks. Then the cameras will go dark until openings. And then after that, we will live stream the Turk trial. We'll take it back to the beginning. So don't worry that we're not going to be on real time with court, but that gives us more FF room. room to FF through the breaks. Again, thank you. Everyone smash the like button on your way out. I'm going to teleport you over to the Young Jerks. You're going to do a cupcake invasion there. Mark Betterow is there. He is speaking. The super chats are turned off. That was one of Mark Betterow's things that he wanted in order to continue sharing his opinion. And so I'm on board with that. I would have turned off super chats at any time. I didn't know that he didn't like them. But I will say that the super chats are so extensive when Mark comes on that it does add a lot of time to the stream to try and read them. He's against it. I would have turned him off at any time. I love Mark. He's a good friend of mine. We are compadres. We're heading over to Young Jerks, Cupcake Invasion. Stay cool, stay kind, stay classy. Thank you, Lana. Love Lana. Follow Lana Delta Turtle on Twitter if you choose to wade in the cesspool over there. So I will see you in the morning. Make sure you have all notifications set, not just some, not just whatever YouTube says they want to give you, all of them, because you're going to want to know what time we're coming back tomorrow for Karen Reed. Then we're going to roll on to Turk to see what a really good judge in the building does. And as I always say a big prayer, says Sam, say a big prayer that jury selection goes smooth and we can get good, knowledgeable jurors. Yes, everyone. Pray to whatever God it is or gods that you believe in. Stay cool, stay kind, stay classy. I love you with all of my heart. If I don't see you soon, I'm going to die, but I'm going to see you tomorrow. We're going to be together all day, so don't worry. Peace, my friends. Cupcake Invasion on the Young Jerks in 3, 2, 1. Safe travels, my friends.